All persons having business before the Honorable Associate Judges, now presiding of the District Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Good morning. I think we should apologize to all of you for keeping you waiting about 20 minutes, and I will do so. And now if we can get started, we'll call we have 3 cases on the calendar. We'll call them in the order they appear. The first case is Evans versus United States. Counsel, you may proceed.
Good morning, and may it please the court. Kelsey Townsend on behalf of appellant Saeed Evans, and I'd like to reserve 3 minutes of my time.
That's fine.
The evidence at trial showed Mr. Evans holding a firearm for no more than a few seconds. During these harrowing seconds, a visibly scared Mr. Evans ducked, pointed the gun, and ran. The jury asked the trial court whether a person in this position, a person who had just acted in lawful self-defense, could continue to hold the gun for a reasonable period of time to ensure the danger had passed. The trial court should have informed the jury, consistent with the defense's proposed instruction, that the answer to their question was yes. A person may continue to possess a firearm for a reasonable period of time to ensure the danger has passed, to cool down, and to safely dispose of the gun. Instead, the trial court informed the jury that a person acting in self-defense could only possess a firearm while they are still in imminent danger.
Ms. Townsend, this re-instruction came after both the defense and the prosecution presented alternatives, and you did not object, or defense counsel did not object to that re-instruction. So what do we make of that?
Well, I would disagree that defense counsel didn't object. There's a point in the record where the court specifically asked defense counsel with the previous iteration, which was substantially the same, why defense counsel thought that that standard was a misstatement of the law. And in response to that, defense counsel explained with the same rationale that it had included in the request it submitted, and explained that a person needs time to cool down, that they need to form the mens rea. And the judge at that point cut off the defense and said, I'm not going to give that. Those instructions are already there. I don't believe those instructions are necessary. So at that point, I think the defense had objected, and the trial court had ruled on the defense objection and said, no, it's, in my view, that's not true. The court then, I think it's worth noting, later, when the court says that it's going to take a recess to draft another instruction, it asks the government to submit their proposal, and the government asks specifically to hear from the defense. And the trial court responds by saying, no, I've given up on that. So I think it's very clear by the time the defense says no objection. I think any defense counsel in that position would understand that the trial court had ruled that the instruction proposed by the defense was not going to be given. And at that point, they were in damage control. And I would point the court to Zeledon and Lucas, which I think both stand for this proposition, that once the defense has made clear its position, and it's been rejected, if they then agree to the trial court's ultimate instruction, that doesn't abandon an already preserved claim. So I think it's quite clear on this record that the defense preserved its objection. And I'd like to discuss about why the trial court's instruction was a misstatement of the law. First and foremost, in Wilson, the DC Circuit held that otherwise unlawful possession. Your Honor, did you have a question? No. In Wilson, the DC Circuit held that otherwise unlawful possession is lawful if it is justified by self-defense. If someone is lawfully entitled to pick up and use a firearm in self-defense, they must also be permitted to hold the firearm for a reasonable period of time following use. This is because possession is a continuous act. It's not something that ends as soon as it starts. So because possession will in every case continue past the point of use, and because the central inquiry of the self-defense doctrine is whether or not a person's actions in response to imminent danger are reasonable, a jury in every case must be able to consider whether a person's continued possession of a firearm is reasonable under the circumstances. In
Well,
addition,
I wonder whether the judge's instruction, the one that the judge actually gave, combined with the availability of an innocent possession instruction if one asks for it, and if the evidence supports it, is not sufficient to meet the concern here. I sort of thought that you slightly mischaracterized the judge's instruction, the one that he actually gave, when you said earlier that you said something like the judge instructed the jury that once the danger is past, the defendant, well, you said it more categorically than that, and I can't quote you because I didn't write it down. But what the judge actually said was that the need for self-defense is present so long as the defendant actually and reasonably believes that he is in imminent danger of death or serious bodily harm. And if he had that reasonable belief, and this is where I think the instruction deviated from what I thought you said earlier, if the defendant had that reasonable belief, then the continued possession is not a violation of the law, even if the belief was mistaken. Now here, one could have argued easily enough that in the seconds after the shooting, and while nobody knew where exactly the attackers had gone and whether they would return and all the rest, the defendant was retained a reasonable belief that he needed to hold on to the gun in self-defense because a return of these people might be imminent. And the defense could also have argued to the jury that, look, innocent possession, that is to say, continuing possession with the intent to dispose of the gun, is a justification, and you've got to have some time to form that intent. And so a reasonable period of time to continue holding the gun while you figure out how you're going to dispose of it properly is covered. And I wonder, given the availability of that innocent possession instruction combined with, though it was not asked for in this case, combined with the instruction that the judge gave, is not enough to satisfy the requirements of the law.
well, I think innocent possession is an entirely different standard that didn't really come into play in this case. So for somebody to claim innocent possession, they have to show an absence of criminal purpose and an affirmative effort to aid and enhance the social policy underlying law enforcement. So it's really an entirely different reason for acquiring a gun in the first place. Here we have acquisition that's as a response to imminent danger that is for purposes of self-defense. And then we're just looking at the period of time when that possession continues. And the reason that we think imminent danger didn't convey to the jury what it needed to under these circumstances, even though it includes the requirement, of course, that the defendant actually and reasonably believe the danger is imminent, is because to a lay person, imminent danger and time to ensure danger has passed, I think sound like very different standards for a couple reasons. I mean, by the plain meaning of imminent danger, we're talking about danger that's forthcoming and danger that's fairly certain to occur. Whereas when we're talking about time to ensure danger has passed, it's really much more of a retrospective inquiry. It's one that sort of fits the facts at this point much more closely. And it's one that allows a defendant to exercise a little bit more caution.
Well, Tom,
yes,
it may go too far in the opposite direction, though, is the problem. I mean, the problem would be that if you really just say, well, he could keep holding the gun until he could be sure that the danger had passed, he could hold it for a few days. I mean, there are people out there who apparently want to kill him. And it would be perfectly reasonable from one perspective for him to say, I'm going to arm myself, and wherever I go and for as long as I need to, I'm going to have my weapon available to defend myself. The law clearly doesn't permit that.
right. But I think that the key there is that I don't think that would be reasonable. And I don't think there are many juries who
I
would
haven't
think
been
that.
following Second Amendment arguments these days. A lot of
Right,
people
but I mean,
very
I think
reasonable.
it's still, of course, the continued possession still has to be relatively responsive to self-defense, right? So if you're carrying it for a few days later, I think the jury needs to be able to consider whether or not that possession is still reasonably related to the initial possession. And in that case, it probably wouldn't be. But what we're talking about here is possession for a few seconds immediately following possession in self-defense.
And,
So I
and
think
the
in a
proposed,
circum,
and counsel, I mean, correct me if I'm wrong, but the proposed defense instruction really accounted for that. It didn't hint at a protracted possession. All it said was enough time for the defendant to regain composure so as to make a decision of how to dispose of the weapon, right?
right. And I think
That's not
that's a
all it said.
requirement in every
That's not all it
case.
said.
Sorry, Judge Glickman?
Well, that's not all it said. For such reasonable time to ensure the danger has passed and for the defendant to regain his composure.
Right. So, I mean, there's two limitations there. A person has to have time to ensure danger is passed and an opportunity to safely dispossess of the firearm. But I think it's really important that this is a jury question, and it should be a jury question in every case, because there are plenty of circumstances. Well, because initially, right, possession is always going to continue for some period of time following use of force. So there has to be some determination made by the jury about whether or not that continued possession is reasonable. And the standard can't be imminent danger because imminent danger is the standard for use of force. So that can't be coterminous with the time period for possession. The implication of that would be that if somebody uses a firearm up until the point when they're last able to lawfully use it, then they immediately become liable for possession. That just can't be the standard.
You know, and I've kicked this around and I haven't been able to find a good answer. Would it have been in violation of any law if Mr. Evans had there on the scene immediately dropped the firearm? You know, you could imagine laws that say something like, you know, you can't leave an open hazard in a public space like that. But I'm not aware of any. I was just curious if you are.
I'm not sure if there's a particular law, but I think, again, the jury should be entitled to consider that might be a dangerous option and that might not be a reasonable way to dispossess. In fact, in Ricks, the Fourth Circuit case, the court had a footnote where it explained that leaving the gun on the floor in that case where the person's partner had been behaving erratically, if Mr. Ricks, the defendant in that case, had simply left a loaded gun on the floor, that might have been dangerous for all parties involved. And so the jury was allowed to consider that and then consider whether under those circumstances where that choice could have been dangerous, it was reasonable for him instead to move the firearm to another room, even though that involved repossessing the firearm in that case. So I think the same can be said here. It's important that the jury in every case be able to determine, based on the different factors, whether or not possession is reasonable under the circumstances.
Okay, well, you wanted to save a few minutes for rebuttal, and we'll give you that time. Let us hear from counsel for the government.
Thank you.
May it please the court, Timothy Cahill for the United States. The trial court here did not err, let alone plainly err, when it gave the instruction at issue. I'd like to begin by addressing the reasons why plain error does apply here. And when the trial court first proposed the key language here, the language that self-defense is present only so long as the defendant actually and reasonably believes that he's in imminent danger, appellant's trial counsel from the outset agreed to that language. On page 16 of the February 8th transcript, when defendant's trial counsel first spoke about the judge's instruction, he began by saying what the court suggested in that second sentence is fine. That second sentence is the sentence that included the language about imminent danger. In fact, he said his only issue was with the phrase time of incident, the time of the incident, which the court actually agreed to remove and did remove in the final instruction.
I mean, you think you need to go to the next page. The bottom of 17 and the top of 18 comes just after that. And he says, the problem I have is you wouldn't necessarily just drop a loaded gun in the street. It could hurt people. I think the case law we supported, I think that means supplied the court with kind of shows that he has to form the intent and then have enough time to come down from and then the court cuts him off and says, no, I'm not going to give any sort of time to come down from the event type of instruction. So why isn't that enough to preserve the exception?
So, Your Honor, I think that exchange needs to be read in context of what came both before and after it. So what came before it is that defendant's trial counsel emphasized this interest or this concern with the time of the incident. That his concern seemed to be that the jury not be under the understanding that self-defense could necessarily only be limited to the time when the shooting was occurring, that it could persist after. And the judge read this request for further language in that context. And so the judge did two things to respond to those concerns. One, he took out the language, time of the incident. And secondly, he says that in response to your concern about the language, right after the exchange Your Honor is referencing, that he would add an additional sentence indicating that it would be up to the jury and the jury alone as a factual question to determine the duration of the need. And that the jury would therefore clearly understand that the defense would be, that they could conclude under some sets of facts that self-defense does persist beyond the use or beyond the incident.
Yeah,
so
but they're different things, counsel. And I just want to probe it. Let's say, we've got a gunfight at high noon and one person shoots and kills the other and shoots him in the head. The need for self-defense at that point has immediately subsided, under the hypothetical. There's a separate question, and this is what defense counsel asked for, is you need a moment to come down, compose yourself, and figure out how to dispose of the gun. So I don't feel like saying it's up to the jury to decide the duration of the need is responsive to the request and to take a beat and figure out what to do with this thing. So if just off camera, let's say Mr. Evans deposits this gun in a trash bin, do you think that the conviction should still be sustained if that's the duration that he held the gun for?
So I'll try to address both your Honor's hypothetical and the early. I'll start with the earlier question about whether or not the court's response proposal was responsive, and then I do want to address your hypothetical. But with respect to whether or not the court's proposed solution was in fact responsive to the defendant's concerns, I think the best evidence that we have is the course of the discussion that follows, in which, by every indication, defendant's trial counsel affirms that it was responsive to the concerns. Defendant's trial counsel agrees, I don't object to that. And then for the duration of the discussion, does not indicate in any way that those concerns remain. And to the extent that the defendant's counsel was unsatisfied with that proposed solution, it was never articulated. Now, with respect to Your Honor's hypothetical about disposing of the gun just off screen. Now, first of all, I do think it's significant here that there was no proposal for an innocent possession instruction, which would have required at least some foundational evidence of both an intent and an attempt to dispose of a weapon. If there were such evidence, foundational evidence, to have warranted such an instruction, then that, just like self-defense, would have been a question for the jury to analyze under the test for innocent possession. If the jury had determined, based on Your Honor's hypothetical, that the defendant had the intent to lawfully dispose of the weapon and safely dispose of it and took reasonable steps to do so, then that would have been a question for the jury. But there was no factual predicate.
Take a separate innocent possession instruction out of the equation. So just on these facts, there's a self-defense instruction. And I think the answer I'm hearing is yes, we should sustain the conviction if there was no innocent possession instruction. And Mr. Evans, and the evidence was that he walked it over to a dumpster and deposited it. You say, no, the self-defense doesn't extend for those extra seconds, right?
Well, Your Honor, I think that's what the government argued at trial. The defense argued against it. If we're looking at it as a question of law, I think that I wouldn't argue, and no one's arguing either way, whether there's sufficient evidence. There was an instruction given, and it's a fact question for the jury. And the jury would have been, to get to Your Honor's point, I think the government believes the jury would have been entitled to conclude that self-defense did not extend so far under the appropriate standard, which is whether or not there was an actual and reasonable belief of imminent danger for the duration of the possession. And the reason I bring up innocent possession was not to sort of go off on a tangent. It's because in some circumstances, one could imagine a scenario where justified possession for self-defense then gets extended because after the need for self-defense ends, the defendant has evidence that he is attempting to lawfully dispose of the weapon.
I actually, counsel, I can't actually imagine a scenario where that's not true. I mean, it seems like the rule the government is advocating is anytime you've got a self-defense instruction like this, they're still guilty unless it's accompanied by an innocent possession instruction, because the idea that somebody sort of instantaneously would drop the gun. You know, I look at the facts of Wilson where he got the gun from the car and fired it a few times. I assume, although the court doesn't say, but a lot of the other cases that we have do say something like this. I assume afterward, he placed the gun back in his car. And under your view, that would be inappropriate. Is that right? That would not be self-defense would not be available for that extra couple seconds.
So Your Honor, I want to draw what I think is an important distinction here. And I believe that the way that this question has been framed by appellant is not quite a correct characterization of the court's instruction, which is whether or not there can be any time after the use of the weapon. And under this court's decisions, the duration of the need for self-defense doesn't hinge on the moment of the use, or even if the gun is actually used at all. It hinges on the duration of the need. And that's a fact question. And the duration of the need could vary significantly under different sets of facts. If we have a set of facts where someone is still being pursued, is still being shot at, which is the case in some of
But Mr. Cahill, in your view, anytime you exercise your right of self-defense and kill the individual who's posing the threat, the possession is coterminous, correct? Because the threat has dissipated?
So there is also an instruction in every self-defense instruction, and was given here, is that the defendant's actions still also need to be evaluated under the moment of the time, under what's reasonable under the circumstances that they're facing, not sort of in cold hindsight. And so the jury is taking that into consideration. But if the jury believes that at that moment, the defendant is aware that the person who is posing the threat to him is now dead, and both reasonably and subjectively believes that there is no imminent danger, then yes, the excuse for self-defense has ended. This court has been very clear that it's a rigid temporal limit.
Suppose you were on the jury in this case, and you're deliberating with your fellow jurors, and one of the jurors says, you know, the government has only presented us with evidence of what Mr. Evans did for just a couple of seconds, 5 seconds. And we don't know what he did with the gun after that, but for 5 seconds after the shooting. And he held on to the gun. Now and the juror says to you, now, I don't think he was in imminent danger anymore. And I don't think that, and I think he knew he wasn't in imminent danger because he separated the clip from the gun. Okay. And the juror says to you, but you could see he was completely shaken and scared and had just gone through an emotional experience in which people have been shooting at him and trying to blow his brains out. And I don't see how we can fault him for not immediately dropping the gun within a millisecond after the black car drove away. He held up, all we know is he held on to it. He could have been completely traumatized. Now, are you telling me we have to convict him? Because I just told you, I don't believe he was in imminent danger, and I don't believe he thought he was in imminent danger because he, separated the clip from the gun and whatever other things the juror might come up with.
Of course. So, Your Honor, in that scenario, I would begin as a fellow juror by pointing out that the jury is entitled to use common sense and conclude that the defendant pretty clearly had possession of the weapon before anything occurred here.
Well, wait a minute. Does common sense mean that the juror could take into account the need for a potential need for a short period of time to compose yourself and figure out what you're going to do?
Not if that's inconsistent with the law.
Let your heartbeat go down and blood pressure go down and catch your breath.
So to be clear, Your
I
Honor,
mean,
the
because
jury's
if
entitled.
that's what common sense means, that's all that the defense was asking for, and the jury needed some guidance on it. And why shouldn't, why didn't the judge then err by saying, well, here's what common sense means in that situation?
So to be more precise, Your Honor, the jury's entitled to use common sense to make determinations of fact. For instance, that the defendant clearly had possession of the gun even before any of this incident occurred. With respect to the legal standards, the jury is not entitled to invent their own legal standards. Even
Put aside the possession. We've all been amused by that aspect of the case, but put aside the issue of the fact that he evidently had possession of the gun before the incident arose. The government didn't prove that, and it's entirely possible that there are others. And evidently the jury was not prepared to base its decision on that basis. They were focusing on other things. So put aside possession before. I'm still waiting to hear how you would, whether you would say to the juror who gave you that question that I asked you, well, you still have to convict because he didn't believe he was in imminent danger for those immediate 5 seconds. He may not have believed anything. He may have believed only, God, I'm glad I'm alive.
So, Your Honor, I think there are several responses to that. One is, on the facts of this case, even though it's a relatively brief amount of time, there is evidence that first, the black car that was shooting at the defendant has now left the scene. Second, the defendant felt safe enough that he actually has a verbal exchange with Ms. Dockery. She asks him a question, he answers it. He also has time to decide to remove the clip from the weapon. And then the video footage shows him making a decision to leave the scene, to flee to a different location. It's unclear how far away, but to flee to a different location while still holding both the gun and the clip. So while this is a brief amount of time.
I'm not saying he needed the time in this case to regain his composure. That's a jury question, whether he needed it or not. And, it might be the case that one could argue the instruction was not appropriate because the evidence didn't support it, although I don't know that I would agree with that. But I'm asking you about the legal correctness of the instruction. I mean, you could argue to your fellow juror, look, he didn't need any time for composure. He had all the time he needed. Okay, that's an argument. But it sounds like you're conceding, without wanting to say so, that the principle that if the defendant continues to possess the gun for a very short period of time to regain composure and figure out what he's going to do, it sounds like you're conceding that that is not illegal possession.
I don't agree with that, Your Honor. So there are different types of excuse. I don't want to go off on a tangent back onto innocent possession, but I do think it's relevant here. The baseline rule here for the charge of felon in possession or unlawful possession of a firearm is that the defendant at the time that he knowingly possesses this weapon, knowing that he's a felon, is committing a crime. And this isn't a case, the self-defense excuse does not negate any elements of that crime. It just excuses it for a very strict period of time. And as soon as the conditions that warrant that strict excuse are absent.
We've made distinctions between, I'm thinking that we've made distinctions between excuse and justification, but maybe you're right. Maybe it's in the excuse category. All right.
Under frankly, either terminology, Your Honor, this court has been clear that the defense of self-defense is applicable only for the duration of the need. And I would point to the Mack decision where this court said, first of all, that the right to self-defense arises and ends with the need, necessity. And then in the very next sentence, this is on pages 1230 to 1231 of the Mack decision, sets forth the specific set of conditions that establish that need. And one of those conditions is the actual and reasonable belief of imminent danger or death.
Right.
But also point
that's the norm. And the question is whether, so your position, maybe it's your position. Your position is that the completely traumatized defendant who is no longer and knows he's no longer in imminent danger, but is still, getting his heartbeat down from over 200 beats per second or per minute, and who can, barely stop shaking, you could say, is guilty of possession of a firearm.
If the only
For that possession. for that period of possession.
For that possession, Your Honor, our position is that there is no so-called grace period to regain composure under the law of this jurisdiction. Yes. Now, to the extent there are other ways that that time period could be excused under some of the scenarios that have been discussed. If the defendant was actively attempting and could show some affirmative evidence that there was an active attempt to lawfully dispose of the weapon, then it could be excused for innocent possession. If the defendant could argue that, in fact, under these circumstances, in the heat of that moment, he believed that he still was in imminent danger of death or bodily harm. Even if looking back on it, it's clear that he was not, then it still could be excused.
So
but if that condition is absent.
Can I come at this from the other direction temporally? Let's say, I get a call from Judge Glickman saying he's in his chambers, but he's going to come over, intent to, well, let's take the judges out of it. Let's say somebody
I was
in their
going to
house
say, I appreciate that.
and gets a call from their neighbor saying, "You SOB, I'm coming over to that house and I'm going to kill you." And that person who received the call is a felon, and they've got a gun in their nightstand. Do you think they can grab it at that point?
And
Even though the imminent danger is not there, the person, let's say they're down the street. They know it's going to take 30 seconds at least to make that run.
Your Honor, sorry.
No, my question is, can they grab it, or do they need to wait till the person comes in the house?
In order to be entitled to self-defense, Your Honor, they need to wait until the danger is imminent. And in fact, this isn't just a hypothetical. The scenario Your Honor has outlined is very similar to the facts in the Mack case. In that case, the defendant actually on his way home from the grocery store was physically attacked by an individual who was clearly looking out for him, found him and attacked him. The defendant got home, was going to return by the same route to the grocery store, and had every reason to believe, as it turned out correctly, that individual would be waiting to attack him on that route. And so he took an ice pick with him. But at the moment that he possessed that ice pick inside his house and left with it, he wasn't in imminent danger. And this court held that based on the rule of Wilson having a strict, rigid time limit, being contingent on the need for imminent danger, that possession was unlawful under a scenario very analogous to the one.
It's not so analogous because he's going back out to the threat, right?
But that wasn't the focus of the court's analysis, Your Honor. The focus of the court's analysis was that at the moment of possession, the criteria that establishes the need for self-defense was absent.
Yeah, it makes sense in some circumstances to say you can't possess a weapon in anticipatory self-defense when it's sort of an ethereal risk and you're not so sure it's going to happen. If that were the case, then you would have people, it would be very hard to prove these possessory charges because somebody could always say, somebody is out there who wants to get me. But in the sense of they're coming, this guy's breaking in the house. Can I pick it up when I hear the door rattle, or do I need to wait for him to break in? That's a very different scenario. That doesn't sound so much like Mack to me. It sounds a lot more, it's more similar to a Ricks type scenario where it's, he's dispossessed himself of the gun. He's dispossessed the other guy of the gun. And now when the guy's gone, he takes it up for a second to eject the clip and put it on a dresser. And the Fourth Circuit said, yeah, I know that's innocent possession, but it seems like the seconds matter, I guess is my point. And Mack doesn't look like that.
And Your Honor, the scenario you've just outlined, I agree under the applicable standard, even the applicable standard the government believes would be a closer call, but it would be a fact question for the jury. It would be a fact question for the jury to determine now if someone is knocking on a door, is that imminent danger? And there would be argument both ways, I would imagine in that case. But the key is that it would be a fact question for the jury.
I think is the one that Ms. Townsend mentioned, that once you've got the gun in your hand and used it in justifiable self-defense, some period of possession is inevitably going to continue past that use, and the danger may not be continuing to be imminent, but the possession will still inevitably continue for some short period, and that seems to me to be one thing that distinguishes this case. Can I ask you one other question? How do you, Ms. Townsend critiqued the reliance on imminence because a defendant who has just been shot at might still feel great fear of danger and still reasonably hold on to the gun until the defendant has some confidence that the danger is past, and yet not be able to say that the danger is imminent. That doesn't appeal to you?
And no, Your Honor,
That
because
argument?
I would return, Your Honor, to the idea that the baseline situation here is that this, as a felon, his possession of the firearm, even without any unlawful intent, the moment he possesses that firearm, he has met the elements for criminal activity. And so it's only excused for the very limit. The excuse or the justification of self-defense is drawn very narrowly and has been drawn very narrowly by this court
Right, but
consistently.
it has to make human sense.
Yes, Your Honor. And so that's why I would also, again, distinguish between the way appellant has characterized this is as the amount of time after the use as not being the test. It's not the test that in this jurisdiction, and it's not the test as it was instructed by the trial court. The jury was entitled to look at the facts as the appellant, as the defendant was actually, the appellant was actually experiencing them, and to determine whether or not his actual and reasonable fear of imminent danger persisted. And if under those circumstances, even if it was mistaken, even if looking at it from retrospect, they concluded that it hadn't persisted, under the instructions they were properly given, they could have concluded that it was covered by self-defense. They clearly did not. They concluded that he had reached a point when he would no longer subjectively and reasonably believe that he was in imminent danger. And at that point, this very narrow, rigid temporal limit of self-defense no longer applies. And as I said, there may be other reasons that could have been established if there was a factual predicate for why the continued possession was excused. If, for instance, he had any evidence at all that he was attempting to lawfully dispose of the weapon and taking any reasonable steps at all to do that. But there was no such
Mr.
evidence, there was no such
Cahill.
request. Yes.
I'm wondering if, what do you make of the situation that Judge Glickman raised, where perhaps objectively the self-defense need has been eliminated, but his heart rate's still, 200 beats per minute. He's still kind of in a very frantic state. In your view, could a jury think that that was a reasonable belief of imminent danger, even though in actuality there was no more danger?
Certainly, just as a general principle, a reasonable belief under the circumstance that the jury, as a matter of fact, concludes is a reasonable belief under the circumstances tied with the subjective belief is sufficient. It doesn't need to be proven to have been true that the threat remained, as long as the defendant convinces the jury, as a matter of fact, that he actually and reasonably believed that there was imminent danger. And so in that respect, I also see that my time is up. So I would ask, if, unless there are any further questions, the government does ask the court to affirm the judgment of the Superior Court.
Thank you. I think we're ready to hear again from Ms. Townsend. Ms. Townsend, we'll give you a few minutes. I wonder if I could ask you in that time, if you could address the question, not of plain error, but assuming you get past the objection that plain error applies, the question of harmless error.
Sure. Your Honor, I don't think, well, first of all, we would argue that the Chapman standard would apply here. As the court explained in Potter, if the instruction goes to a central question before the jury, then the failure to give an accurate statement of the law amounts to a violation of due process. And so the government would have to show beyond a reasonable doubt that the error here was harmless. We don't think that standard can be met. I think what's important to keep in mind is the jury's question here. The jury indicated to the court what time period they were focused on. They were focused on these few seconds immediately following the use of the firearm in self-defense. So any vague inferences that the jury could have drawn about possession at other time periods can't be enough to overcome harmlessness when the jury itself was clearly zoned in on this specific time period.
Well, that's one aspect of the harmlessness question. But the other aspect would be that there was, some, well, I don't want to characterize it, but that there was evidence that the failure to give the instruction you request was harmless because there was no real evidence that he was in need of time to regain his composure. In fact, he seemed to be, as Mr. Cahill argued, reasonably composed. I'm not sure that's the end of the harmlessness inquiry, but I do find myself wondering whether there's any real likelihood that giving the instruction requested would have made a difference.
I think there is. And if we're focusing in on that specific time period, the government argued just now that because Mr. Evans felt safe enough to have a conversation with Ms. Dockery and remove the clip from the gun, that he must have had time to reflect and cool down. And that's not what the evidence was here. The statement of Ms. Dockery in her testimony was at that point in time when Mr. Evans had that conversation, he looked scared, his eyes were wide, he was breathing heavily. And based on that testimony, the court itself admitted Mr. Evans's statement as an excited utterance. So there was a legal finding that at that point in time, Mr. Evans was still operating under the excitement of the event.
What, he's the defendant. Why did the government, the court have to admit the statement as an excited utterance?
Because he was the hearsay declarant.
It's not an admission, I think, is part of the answer to Judge Glickman's question.
Yeah, why isn't it a party admission?
I'm not sure, but there was a finding in the record.
There was a finding, all right, well, all right.
I think it's because it's self-exculpatory. He's saying, I didn't do it, he did it.
That might be right. But in the record, the court made a finding that Mr. Evans at that point in time.
Incorrect, but all right, I can see the thinking. Okay. Go ahead, Ms. Townsend.
Apologies, you all are a step ahead of me. At that point in time, there's evidence on the record that Mr. Evans looked visibly scared. His eyes were wide and he was breathing heavily. That's the testimony from Ms. Dockery at that exact point in time. And then in addition, the government now is relying on this idea that because he removed the clip from the gun, that he felt completely safe. I think it's important to note that the government's argument in closing was that at that point in time, Mr. Evans' gun had jammed. And the government went so far as to say that he would have continued firing if it hadn't jammed. So the government itself had argued that he didn't feel safe at that point in time, that he actually was still attempting to fire.
I don't think they put it that way. They thought he was never in danger. He was still attempting to fire to protect his pride and ego would have been the government's way of.
You're right. That's correct. But they did argue that that was at that point in time, the gun had jammed. So it certainly doesn't support the idea that he felt safe at that point in time based on the government's view. And if the court has no further questions, we'd ask that you reverse.
Counsel, thank you both for an interesting argument. And the case is now submitted. You may log off.
Thank you, Your Honor.
Okay, we'll call the second case on the calendar. Elizabeth Sum Slaughter versus Financial Industry Regulatory Authority. Counsel, if you're ready, you may proceed. Oh, wait, hold on, Ms. Bauer. I think other counsel are still logging in. Mr. Fox, you're not up yet.
I apologize. I don't know how I got in this meeting. I haven't even dressed yet.
He must have hit the wrong button, Judge Glickman. Let me, if I can get him back here.
No, we don't.
No,
we don't want
need
Mr. Fox, Kevin.
But
We have the wrong.
I want to be sure.
Okay.
Ms. Brooks, I don't see,
Here she come, Kathleen. Okay, here she
yeah, I don't see Ms. Warren. Okay. And Ms. Bauer, I take it you represent Ms. Sum Slaughter?
Yes, Your Honor.
You may proceed.
May it please the court. I would also like to reserve 3 minutes at the end for rebuttal.
Sure.
Both parties have submitted extensive briefing and case authority for your review and consideration. So I'd like to focus my arguments today on 3 key points. First, Congress, FINRA, and by proxy, the SEC have put forth certain rules regarding the vacatur of arbitration awards, and Ms. Sum Slaughter has complied with all of those rules to a T. Second, it was an error, respectfully, for the trial court not to afford full faith and credit to the Colorado court that ordered the vacatur And third, Ms. Sumslaughter is entitled to expungement relief directly from the trial court. Your Honors, because FINRA had no interest in the outcome of the underlying arbitration, it had no interest in the outcome of any vacatur of the arbitration award. In FINRA's own rules, it states that an arbitrator in its forum should be viewed, in quotes, much as a judge would be viewed in a court of law. And I think we have to look at this with that in mind. FINRA acted as a forum here, not as a regulator. So just as we were not required here, and it would be inappropriate to name, for example, the DC Superior Court as a party to this appeal, Ms. Sumslaughter was not required, and it would have been inappropriate to name the arbitration forum to what was essentially her appeal of an arbitration decision. The DC
Ms. Bauer, can I get your explanation on what you think the proper order of events was? So she takes this to the Colorado court vacates. At that point, should this have been remanded to FINRA for further proceedings, or was it correct for this whole new action to spring forward?
I apologize, Your Honor, you were breaking up a little at the end. It might have been my Wi-Fi, but I believe I got the point of your question. Yes, so Ms. Sumslaughter, after obtaining the vacatur of the arbitration award, did resubmit to bring her case back through FINRA's arbitration forum. So much like an appeal in court, you would be remanded back down to the trial court. She did attempt to go back through FINRA's forum. FINRA denied access to Ms. Sumslaughter in their forum, essentially for the purpose or for the reason that it had already been litigated was their reasoning in denying access. And because of that, that's why Ms. Sumslaughter had no real other choice or remedy other than to attempt to go through with a state court action.
Well, I suppose her remedy could have been to go back to the Colorado court and ask for a remand. Because I understand FINRA, it appears, understood this as a new separate action as opposed to a remand after a vacatur.
Your Honor, the way with these vacatur actions and the way that they work, and it goes to also our position as to why FINRA wasn't a proper party to that vacatur action, is because, again, it's not looking at the facts of the underlying arbitration so much as maybe the arbitration or litigation here in DC and in the current case would. It's essentially, there's very strict and very specific provisions that allow for the vacatur of an award. And it's that way in both the Federal Arbitration Act and in any state legislature that has a similar act and similar provisions. For example, some sort of manifest disregard of the law, or some sort of example of an arbitrator so exceeding their powers that the final judgment should not stand. So it's not so much another arbitration or more litigation of the underlying facts. Again, as I would state to the court, it's our position that FINRA wasn't a proper party to that action, and therefore we had to keep it so specific. Did this arbitration and did what happened here fall under one of those specific vacatur provisions? And if so, it should be vacated. And then at that point, you go back through the proper remedies and the proper processes that FINRA itself even has in place and mentions in its own rules. For example, in FINRA's own rules, it contemplates these state court actions. And in courts all around the country, as we cited in our briefing, these types of equitable expungement actions are valid claims for relief. Specifically here in DC, we've had several trial courts that have ruled on that issue and found that.
Let me take you back. So I understand FINRA rule, I guess it's 2080, to allow you to go the arbitration route or the equitable expungement in court route. And here she elected to go the arbitration route. And it appears to me that that arbitration has not been sort of finished to completion because the Colorado court vacated the arbitration award. So in your view, can someone elect to follow both paths? Because right now it seems like she simultaneously is maybe in a sort of no man's land, but still in arbitration land in some space. And then she's also bringing an action here, which strikes me as odd because it seems to me that the rule allows you to elect one or the other, but not both.
Well, essentially, Your Honor, the vacatur of the arbitration award, it was our position that ended the proceedings at that point. It essentially nullified the decision. Both parties to the arbitration, Ms. Sumslaughter and Merrill Lynch, were left in the same position they were prior to the arbitration occurring. Ms. Sumslaughter, as I mentioned, did try to resubmit through FINRA's forum. And if that access had been granted, the arbitration proceedings would have started completely over, because it would have been as if the first arbitration was nullified. And then that's why it's our position that she can now bring this completely separate state court action in equity, because the arbitration proceedings that have already occurred have essentially been nullified by a court of competent jurisdiction, which again is contemplated by FINRA's rules.
I'm sorry, I apologize.
Yes, Your Honor, I apologize.
What evidence is there as to the reason the Colorado court granted the motion to overturn the arbitration award?
FINRA stated in its motion to dismiss that the Colorado court lacked the benefit of any sort of adversarial process. But Your Honor, to your point, I'm not sure there was even an adversarial process in the underlying arbitration, only because the firm, Merrill Lynch, did not oppose the expungement, and the customer involved that was notified of the arbitration chose not to participate to oppose the expungement. So,
I mean, that's why it seems so odd to say that FINRA isn't an interested party. I mean, really, the expungement action before FINRA, the only party that's interested in keeping this on her record is FINRA itself, and that's sort of, as I understand Apelli's argument, they're sort of acting in dual roles. They both have an arbitration branch and a sort of regulation branch. And even though nobody's fighting to say, please keep this in your records, the complainant doesn't want to be involved. Understandably, her employer seems to have no interest in having this complaint on her record, and she doesn't want it on her record. That's why it seems so, fictitious to me to say that FINRA doesn't have an interest, is not an adverse party in making sure when it comes to what records they're allowed to keep. I mean, can you explain to me in what sense FINRA doesn't have an interest in its own records?
Sure, Your Honor. I would argue that FINRA cannot be both a regulator and an arbitration forum in every setting. So it's not our position that FINRA doesn't also act as a regulator and have certain functions in that role, including the maintenance of the records, as Your Honor mentioned. But there's a reason FINRA is not named as a party to expungement arbitrations, because they can't be in the same moment, in the same action, both a regulator and a neutral arbitration forum. And likewise with these vacatures, it doesn't stand to reason that halfway through the arbitration proceedings, FINRA should then get to switch hats and suddenly become an interested party. By way of example, there's a very different standard between the vacatur motion and the DC complaint, as I mentioned, as it pertains to which function FINRA takes in each of those types of actions. For the vacatur action, for example, as I mentioned, FINRA had on its neutral forum hat. So it had no interest in the outcome of the vacatur because it had no interest.
Well, that's very formalist. That's very formalistic. In reality, FINRA has an interest. FINRA says, look, we had a fair arbitration. It's important in our regulatory function to see to it that the public knows that there's been this complaint. That's the whole purpose of this registration process that we go through and this disclosure process. So we're going to defend that. If we have a very strong regulatory interest in defending fair arbitrations that reject claims for expungement. And so it seems to me quite clear they have a regulatory interest in it. The question and therefore that they should be allowed to participate or given notice of the proceeding. And what's more, it strikes me as odd to think that FINRA has to then, if a judge in another court in which FINRA did not appear vacates the arbitration award, not because there was anything wrong with the award or the determination, but because what appear to be the only parties to the award have kissed and made up and don't feel like having it on the record anymore and would like to, in effect, it's like a consent judgment or a settlement that is presented to the judge for approval. And if the judge grants that, FINRA has a strong interest in saying, well, but that doesn't mean that the arbitrator got it wrong, and therefore it doesn't mean that we should expunge this from our records. how do you respond to that? That's why I asked you earlier, what, it seems like the Colorado judge did not have a valid reason to think that the arbitrator had done anything wrong or that there was something wrong with the arbitrator's rule.
Your Honor, I would argue that, for example, here in the DC action that we brought, FINRA, as I mentioned, there's two hats, and FINRA had on its regulator hat in this action, because now Ms. Sumslaughter is asking for FINRA to be bound by a certain order to remove certain publications from its own databases. So now FINRA has an interest in the outcome of this action and should be named as a party. But as I mentioned, Your Honor, by way of example,
If they have an interest in this action, then why don't they have an interest also in the action to preserve what they think is a good arbitration decision?
Well, Your Honor, by way of example, as I mentioned, in FINRA's own rules, they equate or compare a FINRA arbitrator and a FINRA arbitration forum to a court. And Your Honor, just as what we would not name a superior court here as a party, and they would have it wouldn't be appropriate for them to have some sort of arguments in their own defense, yet they would still be bound by whatever Your Honor's ordered in this
administrative agency actions all the time. We have administrative agencies which have a call it a judicial component, administrative trials and so forth, and administrative appeals. Well, sometimes the administrative agency also defends or is party in those very same proceedings. It's not obvious to me that just because they, in that sense, just because the administrative agency in that sense has more than one hat, that means the administrative agency doesn't have an interest or can't proceed as in effect, a party.
That's true, Your Honor, but it's our position that if FINRA did intend for that to be what is required in order to vacate one of their actions, they could have very easily included it in their own rules, as they did for the confirmation of words, for example. The SEC these rules go through a huge review process, as I'm sure Your Honors are aware. And the SEC likewise did not require FINRA to change its rules in that way. I'd also argue, Your Honor, that Congress and the Federal Arbitration Act, as well as the Colorado legislature and the DC legislature, and frankly, every legislature in the country that I've come across in these types of cases, has contemplated the vacatur of arbitration awards, and they include some sort of mechanism for vacatur in their rules, and none of them has required the naming of an arbitration forum to a vacatur. And again, including FINRA, that's not even in their own rules when they so clearly contemplated it in different types of actions related to their own awards.
It might have been, I can see the point that it might have been better to had FINRA had a rule that specifically addressed this situation. But when the issue is when the issue is the effect of the Colorado court's vacatur action on FINRA, and whether another court has to order FINRA to act in a certain way as a result of that action, it seems to me that the absence of a provision in the rules is not necessarily dispositive.
Well, I would argue that it's important, Your Honor, here, because the Superior Court seems to have decided that the Colorado court's vacatur has no effect because Ms. Sumslaughter failed to meet a requirement that frankly doesn't exist. So I would argue that that's why.
Just the normal, it's not so much that, it's that the Colorado decision was fine as a decision resolving any dispute between Merrill Lynch and Ms. Sumslaughter. But when you try to come into a different jurisdiction with waiving that decision and apply it to an entity that was not a party to it, principles of collateral estoppel and fair faith and credit don't seem to require that, because FINRA was just not a party to that proceeding.
Well, I would argue, Your Honor,
and FINRA can perfectly well say, we have no obligation to, as a result of that vacatur, to remove something from our records or from the public registry. We think it's very important, and that decision didn't speak to us. And we're satisfied that the arbitrator's ruling was fine and indeed was not even cast into doubt by the vacator.
I would argue, Your Honor, that if the court is inclined to say, as I believe Your Honor just did, that this Colorado action was fine as it pertained to those parties, and I would argue that if that's the case, then the arbitration award was nullified. And if the court is inclined to believe that that's the case and that order was valid at the time it was issued, then there is no collateral.
Your position is that there must be hundreds or thousands of these cases where the arbitration parties are the broker or whatever the agent is called, and the employing firm. And in name, the arbitration is between them. And maybe the customer's involved too, although in this case, I guess it's not. But in every one of these cases, if the broker loses, the broker can say to the employer, look, it's not in either of our interests to have this thing on the public record as a complaint against you and me. So why don't we just go into court somewhere and say to the court, look, we've made up. We never really had this arbitration award confirmed, and we no longer want it confirmed. And we're the only parties to it, and we no longer want it. So judge, vacate it. And here's a signed agreement between us, if you need one, that says that. And the judge says, okay, that's fine with me. If the parties don't want it, who am I to, keep it on the record? That can't be right. That would just be, FINRA would eventually figure out that they ought to have a rule that saves them all a lot of trouble. But what I've just described can't possibly be the way these things are going to go, can it?
No, Your Honor, and it frequently isn't. I handle a lot of these types of vacatur actions, and I would say many more times than not, the firm does oppose these types of actions because, for example, some firms argue that they have an interest in promoting the fact that they reported the correct information. So again, even in a situation like that where the firm is opposing, it's still our position, Your Honor, that FINRA would have no interest there because the vacatur itself, I think it would be a mischaracterization to say that the vacatur order is sort of against FINRA or holds FINRA to any sort of standard. It really doesn't.
Well, it depends on the reason. If there's a good reason to vacate and the arbitration award, and FINRA is persuaded of that reason, then FINRA ought to support the vacatur. And they should not. They could be said not to have an interest in preserving the arbitration award, but that hasn't been shown here.
Your Honor, I would say it is important, the fact, and as you mentioned again, that there maybe should be some rule and there isn't some rule to this point. I think it would be inequitable for Ms. Sumslaughter to be prejudiced for not naming FINRA to an action where they were never a party to the underlying action. And this is sort of akin to an appeal of that action. When there's no rule or case law in the book to suggest that she needed to do so. So while the court may believe that should be the rule, and while the Superior Court clearly believed that should be the case and that might be the fairer way to handle things, it just wouldn't be equitable to hold Ms. Sumslaughter to that standard when that standard so far hasn't existed. I would argue as well, Your Honor, to the collateral estoppel point, that we cited the Hogue v. Hopper case in our briefing, which is where, as this court I'm sure is aware, and this court holds there's 4 different factors to consider when applying and considering whether collateral estoppel applies. And again, Your Honor, if the Colorado vacatur order was valid, then there is no valid final judgment on the merits here, and collateral estoppel doesn't apply.
Do you want to respond to Sterniolo, Appellee's 28K letter, where the Colorado courts seem to disagree with that?
Sure, Your Honor. I would argue that in that same court, there's been differing, they've sort of gone back and forth on whether equitable expungement is a valid claim for relief. And I would also argue, we submitted several cases in this jurisdiction.
I'm not talking about equitable expungement, whether or not that's a valid form of relief. What Sterniolo said, I think pretty clearly, was, well, whatever that court in Broomfield did, as between these parties, Sterniolo is collaterally estopped from attacking the not expungement, for lack of a better word. So do you have a reaction to its collateral estoppel ruling?
Yes, Your Honor, I would stand by the fact that, number one, this is a trial court in Colorado, and I understand that we're dealing with a Colorado vacatur order. But even so, as it pertains to this DC case, of course, this is persuasive authority that is far less persuasive than what this court has held in its own collateral estoppel rules. It's our position that the court in that case got it wrong. Just as it's our position that the Superior Court here got it wrong, Your Honor. If you look at the law and you look at these cases that are out there, you look at the history of these types of vacatur motions.
I don't mean to interrupt, but I know we're low on time, so just one. You cite to a lot of cases that kind of present the typical arbitration action, which is where you have two opposing parties who are in disagreement, and the court says, yeah, the arbitrator is clearly not a party to that dispute, and if those parties want to resolve their dispute amongst themselves, they're free to do it. This is quite different from that, and so I wonder if you have anything that looks remotely like this, where the arbitrator was really, has their own interest in seeing that this is a regulator. Do you have a case where an arbitrator / regulator has been held to have no interest in what happens next? I'm sorry, that's kind of a confusing question. I'm just trying to, the nub of it is, it's odd because this does not really look like a typical arbitration. It looks like the only interested party against Ms. Slaughter is FINRA. Now, I understand that's a little bit strange because they're also the arbitrator, but in reality, that's what it looks like. Are any of the cases you're citing, do any of them look like that at all?
I know that we cited Stas v. Schwab, which was, I believe, a California case related to an arbitrator. But frankly, Your Honor, I believe this area of law as it pertains to FINRA is fairly new. There isn't a ton of case law. Similarly with the equitable expungement claim, there just isn't a lot of case law out there yet on these sorts of issues. As it pertains to, as Your Honor is talking about, where it's a regulator like FINRA, there just isn't a lot out there yet. Again, I would argue, Your Honor, I know briefly, I know I'm out of time, but I would just respond to that as well by just saying that, again, I don't believe FINRA is an interested party because this is a customer complaint. So truly, in the underlying case, the only real interested party is the customer that complained, and making sure that there's some sort of accountability to the advisor that they complained about. And again, the customer here didn't oppose either. So knowing that I'm out of time, if the court has no further questions for me at this point, again, I'd reserve 3 minutes if possible for rebuttal.
We'll give you a few minutes in rebuttal, and I'm sure we'll have questions for you then. Let us hear from counsel for FINRA.
Thank you, Your Honor. May it please the court, Kathleen Warren, counsel for the appellee FINRA. Ms. Slaughter sought relief through FINRA's arbitration forum and is now trying to circumvent an unfavorable result by petitioning this court to expunge her record. She brings this case in equity and asks this court to agree that a party can vacate an arbitration decision without notice to the party in interest. Specifically, she asked this court to permit vacating an arbitration award without notice to the regulator, whose statutory duty is to maintain this information, and ultimately, if she is successful, who must expunge this information. And in doing so, she's attempting to relitigate identical issues decided previously on the merits solely because the relief she sought was denied. She brings a claim here for the same relief. However, her claim is precluded by collateral estoppel.
So, Ms. Warren, how do you give collateral estoppel effect to an arbitration award that has been vacated by a court of competent jurisdiction?
We don't believe that the vacator is void in this case, and that's because Ms. Slaughter is attempting to offensively use it against FINRA, who was not given any notice of the action, to preclude collateral estoppel from applying here. The arbitration was a full decision on the merits and would have been confirmed if FINRA had potentially been given notice. They were never given that opportunity.
So wouldn't your course be to then intervene and take an appeal in Colorado? I mean, we still have the fact that there is a court that has vacated the underlying order.
So FINRA would have intervened had it received notice. It did not receive notice of this action. The first possible notice to FINRA that this had occurred was when Ms. Slaughter brought it back to FINRA for a potential re-arbitration of this notice. So had FINRA received notice, it would certainly have intervened as it has done in numerous other expungement cases when a similar situation has occurred.
And so I guess that seems to me to cut against you. If you know how to intervene, and it seems like from the briefing, you now try to intervene in this Broomfield court, which is where, for whatever reason, all these actions seem to happen. So this one, you snooze, you lose.
Well, this one happened before we realized that the forum shopping that occurred here happened. So just to step back and to understand the factual predicate here, this was a broker registered with FINRA. She lives and works in Tennessee. And this customer dispute initiated in 2011. That went to arbitration that was ultimately settled by her employer, Merrill Lynch. In 2018, Ms. Slaughter brought an arbitration in order to expunge this record from CRD. The situs of that arbitration was in Atlanta, Georgia. The arbitrator in that case denied expungement. So following that award where expungement was denied, they then filed this motion to vacate in Broomfield County, Colorado, a court completely unrelated to any of the issues regarding the underlying arbitration whatsoever, completely unrelated to FINRA, and provided no notice to FINRA at the time. So it wasn't until later that FINRA had any idea that this attempt to vacate had occurred.
How much later? I mean, just to Judge Ali Khan's point, at what point after the Broomfield court's order did FINRA first receive notice of what had occurred? Was it within a time that would have permitted a notice of appeal? Do you know what duration we're talking about?
Well, so FINRA, Ms. Slaughter attempted to bring the case back to FINRA in its arbitration forum following that. And that would have been, I believe, several months following the decision from the Broomfield County Court.
Why didn't FINRA take it back? Because I mean, it seems to me in the ordinary course, there's an arbitration award, it gets vacated, then it goes back for the arbitration or the arbitrator to fix whatever went wrong.
So in this case, FINRA's position is that she had a full and fair opportunity to arbitrate the issue. She was attempting to do what she's attempting to do here again, which is relitigate it. It was a full hearing on the merits with evidence submitted, both parties represented by counsel, and the arbitrator issued a decision. So she had a full opportunity to do that at the arbitration level, and she was not permitted to do another opportunity here by seeking an improper vacator of the award without giving FINRA notice.
But what do you think the proper? So I mean, I have two alternatives that I'm hearing. If she wanted to pursue vacator in the Colorado court, did she need to name FINRA as a party, or could she skip naming FINRA as a party so long as she provided notice? What's your view on the proper method of doing that?
Either of those options, Your Honor. If she had just provided notice, then FINRA could certainly have intervened in the case. So FINRA did not necessarily need to be named as a party, but they needed notice to allow them to have the opportunity to intervene. So
what happens if Merrill Lynch in this circumstance had then gone to the Broomfield court to confirm the arbitration award? Would FINRA also need notice and the opportunity to participate in that circumstance?
So under FINRA Rule 2080, when a party seeks to confirm an arbitration award regarding customer dispute expungement, FINRA does need to be named. So yes, if a party had sought to confirm this award, FINRA would need to be named under FINRA rules.
Gotcha. So you anticipated my next question, which is FINRA rule sets forth when FINRA needs to be named, and it is silent on this vacator situation. So what authority do you have for FINRA needing to be named?
The full faith and credit clause. So essentially what's happening here is Ms. Slaughter is attempting to use this vacator against FINRA to seek expungement relief again, which we believe has been fully litigated on the merits. She had every opportunity to seek expungement previously in the underlying arbitration. And when she seeks to do that affirmatively against FINRA, FINRA deserves to have notice of that. The judgment should not have preclusive effect, essentially, against FINRA without them having an opportunity to be heard in that case.
So maybe I'm missing something here, but what preclusive effect? The underlying arbitration order nor the vacator don't compel FINRA to do anything. This just resets the stage for this to start fresh in the superior court to determine whether or not there's a basis for equitable expungement.
So it allows this additional lawsuit to be filed against FINRA. So you're correct that in the underlying arbitration, the arbitrator decided that Ms. Slaughter did not meet the requirements under Rule 2080 for expungement. Rule 2080 is designed to evaluate the potential regulatory value of the issue that's been disclosed pursuant to broker check. And Ms. Slaughter did not meet her burden in that arbitration. This would allow her another bite at the apple to relitigate an issue that's been litigated previously. And the only reason that that is potentially possible is because Ms. Slaughter filed a case in a random jurisdiction and did not give notice to the real party in interest, FINRA.
What is your understanding as to the reason the Colorado court vacated the arbitration award?
Because it was an unopposed motion. It was a motion that Merrill Lynch filed a statement of no opposition. And as a result, there was no adversarial process. There was no consideration of the merits based on the record that we have before us. The court entered the proposed order submitted by Ms. Slaughter.
And it was as simple as that. It was like a default judgment. I guess.
Yes, Your Honor. There was no hearing. There was no obviously opportunity for anyone to intervene who had an interest in the regulatory value.
But by the time that FINRA learned about the vacatur, did FINRA have any possible route to go to the Colorado court and seek to overturn or correct the vacatur?
Not to my knowledge, Your Honor. So the biggest issue with the Broomfield County action is that there was no one there who was representing FINRA's interests, nor could there be. FINRA's interest as a regulator is tied to ensuring that the information disclosed on BrokerCheck has meaningful investor protection. And certainly Ms. Slaughter and Merrill Lynch can't represent those interests for FINRA. And that is why FINRA has an interest here in its role as a regulator. And
FINRA doesn't participate in the arbitration forum as a regulator. It is solely as an arbitration forum.
Correct. That was exactly the point I was about to get to, was FINRA does carry two roles as part of its role in regulating the securities industry. They serve both as a forum for mediating or arbitrating, securities related disputes, as well as a regulator for the securities markets. And where the regulator hat goes on is once an award is rendered relating to expungement of customer disputes, that's the bright line where FINRA's regulator hat is now put on, and it has an interest on what happens following that award, because they are the party who are charged with ultimately removing information if that's what's ordered by a court.
In the initial arbitration, could FINRA have participated as a party if it wanted to?
No, it could not. In that initial arbitration, it is merely the forum. It has not yet taken on its role as a regulator regarding the expungement request of Ms. Slaughter.
I mean, I guess I don't quite understand the answer to that question. They already have a record of this complaint. And if they think, why don't they have an interest in opposing expungement, even at the arbitration stage?
Why don't they have well, if the case is being arbitrated, then FINRA arbitrators are trained to essentially apply the 2080 factors, which is what ensures that the regulatory import of the information sought to be expunged is considered. So the arbitrator who is deciding the case, serving as a neutral in this situation, is actually applying the 2080 factors.
To some extent, there was adversity in before the arbitrator, right? I mean, did the customer participate at all?
The customer did not, but interestingly, in that case, Ms. Slaughter did give notice to the customer. So the potential party who would have an interest was given notice in that arbitration, as compared to the Broomfield County case, where FINRA, who had an interest, was not given notice. The customer did not participate. Merrill Lynch did not submit any sort of opposition in that case, because as stated earlier, in this specific situation, Merrill Lynch is aligned with its employee, Ms. Slaughter. They both have an interest in having her CRD and BrokerCheck records being clear of any customer dispute disclosures.
So in this case, Ms. Slaughter had in effect the burden of proof before the arbitrator, and the arbitrator basically found that she did not carry it.
That's correct. The arbitrator, in considering an expungement request, has to apply FINRA Rule 2080 under FINRA's Code of Arbitration Procedure and has to make a finding.
Ms. Warren, I apologize for interrupting, but you hit on something that seems quite central. So The arbitrator is not considering a claim for equitable expungement. They're considering a claim for expungement under FINRA's rules. And so the question before the Superior Court is purely one of equity on which, as I understand it, the arbitrator has no authority to opine.
So I would disagree that the issue before the DC Superior Court is clearly one of equity. That's one of the allegations that the plaintiffs have made in their complaint, but they also seek relief under FINRA's rules and cite repeatedly to FINRA's rules. And this is an important fact because of the number of expungement cases that are currently pending in DC Superior. There are a number of trial court decisions who believe that there is a cause of action that's been established under Rule 2080. And FINRA respectfully disagrees that that rule establishes a cause of action. Rather, it is a procedural rule to use as a framework for consideration of expungement requests and the regulatory value of such requests.
So then don't we need to remand for the Superior Court? Like if we assume that the arbitration covers just the FINRA rule question and we give you the win on that, that doesn't address the question of whether there exists a cause of action for equitable expungement. And I think you just agreed that that is not something that the arbitrator could have passed upon.
So in this case, the relief sought is the exact same relief. It is expungement relief. Ms. Slaughter is seeking to have this particular information removed from the public record. That is the same relief she seeks in the DC Superior Court action. Putting a different title on it, it is the exact same for relief. So for issue preclusion purposes, it doesn't matter, it's an identical issue. So I would cite you to the Smith v. Jenkins case, as well as the Hogue v. Hopper case that the appellant mentioned earlier. In that case, specifically, it says a party whose claims have been decided in arbitration may not bring the same claim under new labels. That's all that's happening here, is that she's putting a different label on it to bring it before this court. It is the same relief that's sought and has already been decided by the arbitrator.
How is it the same relief if one's regulatory expungement and one's equitable expungement?
They're both expungement. Essentially, what she's asking for is for FINRA to remove the information from the database. So if the arbitrator had granted expungement in the underlying arbitration, then Ms. Slaughter would need to have that confirmed by a court of competent jurisdiction in order for that to then come to FINRA for them to expunge it. It's the exact same process. It's the exact same relief that is sought, which is removal of this information from the public database. So
Well,
there's
just to
nothing
be-
different about the two actions except the label that plaintiffs are slapping on it in an effort to avoid collateral estoppel.
Well, just to be clear, if Miss Slaughter loses before the arbitrator says you have not met the requirements of the rules for expungement, and then goes to court and appeals, seeks to, and gives notice to FINRA, and goes to court on the grounds, on one of the limited grounds that an arbitrator's ruling can be overturned. The arbitrator was not neutral. Pick your special ground. You would agree that the court would have grounds, jurisdiction to consider that and could overturn and vacate the award if it properly found those grounds met, I take it.
Yes, I mean, yes, after an arbitration award regarding expungement is rendered, there is an opportunity to seek to vacate that. FINRA would say that.
So even to this day, irrespective of the Colorado, well, there may be, leaving aside questions of time requirements, so I shouldn't have said even to this day, but if it was timely, regardless of the Colorado decision, Ms. Slaughter could have gone to, say, Superior Court or any court, I guess, given notice to FINRA and raised whatever issue she wants to raise that would justify an equitable expungement. Is that right?
She could have sought vacator of the Arbitration Act and given notice to FINRA, yes. And if that had happened and FINRA had an opportunity to act in that proceeding, we would not have a collateral, and it was vacated, we would not have a collateral
Not have a collateral stop, right. So now, and this is a long way to get back to a question I just wanted to pursue that Judge Alicante asked you. On the question of the collateral estoppel effect of the arbitrator's ruling in this case, I am thinking that where the Colorado court vacated that ruling for the reason you've posited, which is simply the party requested and it's unopposed, and not on the merits or for any defect in the ruling. There's no reason why that arbitrator's ruling should not still have collateral estoppel effect vis-a-vis, should not have collateral estoppel effect against Ms. Slaughter in another proceeding. Am I right about that? Or do you think the vacater, even for for something that is not a defect in the arbitrator's ruling, robs it of collateral estoppel effect? Did I make that question clear enough?
Well, I hope that I'm understanding your question, but so as I understand it, you're asking, could the vacator action be used against a different party other than FINRA and be valid?
Yeah, I think so. In other words, FINRA's main argument has been, well, you know, FINRA was not a party to the Colorado court proceeding, but and nor was it a party to the arbitration. But that doesn't mean FINRA can't invoke collateral estoppel against Ms. Slaughter here. And what I'm wondering is whether, where the arbitration award was vacated in the proceeding that FINRA was not a party to, but vacated for reasons other than any defect in the arbitrator's award. Whether FINRA can still rely on the arbitrator's decision for its collateral estoppel consequences.
I mean, so
I think I'm confusing you because I'm putting this in FINRA's role, which, let's just take a normal case where, you know, Bob and Alice have an arbitration and Bob loses, and then he appeals to, and the court says, well, it's not contested, so I'll vacate the arbitration award. There's no defect in the award. I'm just vacating it because you've asked for it and it's not opposed. And then Bob sues Ted, and Ted says, well, I'd like to, you know, you lost that arbitration, and I'm going to invoke that arbitration for collateral estoppel consequences. Can Ted do so in the hypothetical I've just given you, where the award, where the vacater of the arbitration award was not because of any defect in the award?
Well, if there's no way to collaterally attack the vacator award and it meets the principles of collateral estoppel, meaning that the same issue was litigated, it was a final judgment on the merits, it was a full and fair opportunity to litigate, and the arbitrator's decision is essential to the judgment, then yes, it could be.
Even though the award was vacated?
Yes, if it's not subject to any other kind of collateral attack. I mean, in this situation, if FINRA had been given notice of the vacator action, participated in it, and the judge ultimately vacated the arbitration award, then yes, we do not believe that there would be collateral estoppel preclusive effect of the underlying award.
Can I ask, just this will be my last question. I know we've taken you over your time, but as I read the trial court's ruling in this case at pages 22 and 23, she's not giving preclusive effect to FINRA's arbitral award as to the claim in equity. What she says is the plaintiff is seeking equitable relief here, and in my view, it would not be equitable or in the interest of justice to allow this. So it seems to me you have a merits ruling on the claim for equitable relief. So this kind of gets to the question of whether or not, you know, if FINRA's arbitration doesn't have preclusive effect as to an equitable claim that it never had authority to decide, maybe we should remand it. My reading, that was, I think, suggested by Judge Ali Khan, and my reading of the transcript is that the trial court actually ruled on the merits of the equitable claim and said equity does not countenance vacating this award. So that's how I read it. Did you understand the trial court to not even consider the claim in equity because it was precluded by FINRA's prior action, or do you understand it to rule on the claim in equity and say there is no equitable basis for vacater here?
No, I believe that the court did rule that collateral estoppel precluded based on the underlying arbitration, and did determine that it would be inequitable to allow the Broomfield County vacator decision to be used offensively against FINRA when their interest was not properly represented in that action.
I take it the only equity argument here was the argument based on the vacatur by the trial court in Colorado.
Well, in plaintiff's complaint, they seek expungement under an equitable theory as well as under the FINRA rules.
Right, but the equitable theory is based on the vacatur by the Colorado court, not on any other equity, is it right?
No, the underlying complaint here seeks equitable expungement of FINRA's records. That's what the cause of action that plaintiffs have alleged. We disagree
Right.
that that is.
What's the equity that's being claimed here that justifies the expungement?
What do plaintiffs claim? What equity is required? They believe that there's no regulatory value, that FINRA has no interest in continuing to publish this on Ms. Slaughter's record.
And they believe that because why?
Because they believe that
the Colorado court vacated the award.
No, they believe it because they don't believe that the regulatory value of the disclosure meets the 2080 requirements. They basically allege under all three subparts of 2080 that either the allegation is
So in other words, so their equitable argument is really based on the rule.
Yes, Your Honor.
So it's not really a new equitable argument. It's just, I see.
If the court has no further questions, we would respectfully request that they affirm Judge Pan's decision from the lower court. Thank you very much.
Thank you. Ms. Bauer, we'll give you a few minutes in rebuttal.
Thank you, Your Honor. I'd like to start with the last point that Your Honor was just discussing with Appellee's counsel regarding our equitable claim and what we brought it under. Your Honor, it's clear from the complaint that the equity interest here for Ms. Slaughter is the fact that this disclosure is significantly and negatively affecting her professional and personal reputation. So we use some of FINRA's own language as guiding posts for the court. It's very clear in our complaint, we use clear language to even say that the court is not bound by FINRA rules. It just may, it may use them as guidance. And here's some things that even FINRA itself would pick up on in its own rules, including the clearly erroneous standard, factually impossible, et cetera, from FINRA Rule 2080. But Ms. Slaughter did bring a complaint in equity for a completely separate, as a completely separate claim for relief.
Well, I'm not sure I understand. I mean, the notion that the consequence of her actions as determined by in the arbitration proceeding is affecting her reputation is not that doesn't state an equitable claim.
Your Honor,
what's the basis for her claim that this is inequitable? The basis is that she should have won the arbitration, if I understood Ms. Warren correctly.
I would disagree, Your Honor. It's our position that this action in DC, frankly, has almost nothing to do with the arbitration. It's a completely new and separate action because, again, the vacatur nullified the underlying arbitration. So it's as if that didn't exist. It's as if that arbitration award doesn't exist. So the equitable interest pertains to the actual publication, FINRA's publication of the complaint, the customer complaint, not anything related to the arbitration. Is completely separate, Your Honor. And I'd also like to point out that I think Judge Alican touched on an important point. It's clear from the language in the claim for relief in the complaint that, again, Ms. Slaughter is not asking for any sort of remedy in accordance with FINRA rules. It's clear throughout. It's very specifically worded. The court could choose to expunge for any equitable reason, not just that the framework offered by the FINRA rules.
And I just have a record question. Have you supplied us with the complaint in the Superior Court?
I believe it was attached in the appendix, Your Honor.
I think it's in the appendix.
I believe so.
Look, I didn't see it, but maybe I missed it. Looks like it's there.
I apologize, Your Honor. I'm having technical difficulties loading loading the appendix.
It's right at the front.
Oh, okay.
I
Thank
just
you, Your Honor.
skipped over it.
Not opening for some reason. I apologize. I would like to mention, Your Honors, that we've already discussed at length that there wasn't any party that opposed Ms. Sumslaughter's underlying expungement request in the underlying arbitration. It's important to note, as we noted in our briefing, that there was no evidence presented in opposition whatsoever, yet somehow the arbitrator made the decision to deny the expungement request anyway. It's our position that that was an unfounded decision. There has to be some mechanism for judicial review of rogue arbitrators issuing awards that are completely unfounded in the evidence
I
presented.
think Ms. Warren agrees with you. I think she says the path for that is, I guess, you go to Broomfield, but you somehow bring FINRA in as a party.
Your Honor, first of all, to clear up I think there's some question as to why in Broomfield and all of this. First of all, my firm is based in Broomfield, Colorado. It's our position, again, that the arbitration is in one place, the parties are housed in different places. We chose Broomfield. We're housed there. In this DC case, the reason DC was chosen is because it has, again, nothing to do with the award or the vacatur. It has to do with FINRA's publication of these disclosures on their databases, and the department that houses those databases and maintains those registration records is based in DC in FINRA's principal office. So that's why we brought the cases where we brought them. I just wanted to clear that up because I believe there's been some discussion about that. But to get sort of back on track, Your Honor, I think it's reasonable to see how the Colorado court may have looked at the underlying record here and said, yeah, there really wasn't any evidence to support this decision. This, based on the record I'm seeing and based on the decision that came out, these two things aren't meshing. I think it's reasonable to see that. And so I don't think it's the case of this court just sort of rubber stamping things to go through. I think this is an example of a case where it makes a lot of sense. And this is what vacatur was made for. And again, it's contemplated in FINRA's own rules, yet they affirmatively chose not to require themselves to be named as a party. So I know I'm out of time, Your Honors. Again, we would ask that this be remanded back down to the trial court if there's no other questions for me.
Counsel, thank you both very much. The case is now submitted and you may log off. The third case on the calendar, in re Mary Chris Dobby and Reagan Taylor. Good. I see all counsel before us. Mr. Little and Mr. Simeon, as respondents counsel and the appellants here, how do you wish to divide up your time?
Your Honor, I'm going to go first for 10 minutes and then Mr. Little will follow for 5. We were going to try to present the arguments in our brief, meaning that I would address the intent issues under all the rules, 3.8E and 8.4, and Mr. Little will pick up with the protective order of the tribunal.
Okay, and we recognize these are tight timeframes. We'll be a little flexible.
Thank you, Your Honor.
Thank you.
May it please the court, I'm Tim Simeon, representing respondent Mary Chris Dobby. The 3 disciplinary rules on appeal here, rules 3.8E, 8.4C, and 8.4D, require somewhat different mental states for violations, but our core point as to all 3 of the rules is the same. We think respondents' conduct makes clear that they lacked the mental state required to violate any of the 3 rules. So before turning to the legal issues, I was just going to take about 30 seconds to quickly summarize the conduct that we think is important. the first thing that respondents did here when they received the investigator's report, the Collins report, is they recognized it raised a Giglio issue, and they told both their supervisor and his supervisor. And the second supervisor elevated it a third level to the Lewis Committee. Respondents then repeatedly bugged all of their superiors for further guidance. And when they got that guidance, they followed it.
So, Mr. Simeon, I think we're all pretty familiar with the facts and the conduct at issue. So if I could ask you to just jump in on Rule 3.8E and ask what standard you think we need to apply there.
So our argument, well, we really have, I think, two arguments on the standard itself. Our argument is that the word intentionally limits violations to where the prosecutor acts with the conscious intent not to fulfill her obligations under the rule. So we are reading the word intentionally to require conscious intent. But we're also arguing, I just want to be clear up front, we're also arguing that even if you accept the board's construction of intentionally, which we think is actually an entirely different mental state, we think the board interprets intentionally to mean what is usually called knowingly, awareness of one's conduct. We think that even if you agree with the board on that issue, and I want to talk about why you shouldn't, respondents still didn't violate the rule because they didn't know that their conduct would result in a failure to disclose. Is that responsive to your question, Your Honor? I'd like to start. Oh, I'm sorry.
So I guess that is responsive. So let's start with intentionally, and what does it mean to have a conscious intent as opposed to just not do something accidentally or inadvertently?
So I think I want to make 2 points, and the first one's kind of a meta point. We have kind of a core disagreement with disciplinary counsel here about how you answer that question. We think that the intent of the drafters is kind of the fundamental interpretive principle here. Disciplinary counsel says relying on the intent of the drafters is like relying on the submissions of lobbyists. But I just wanted to quickly note that, in Ray McBride, which we cited in our brief, the court emphasized its special supervisory responsibility in disciplinary cases to get to the rule that the drafters intended. So the court said, we'll even revisit our precedents more readily to make sure we're getting it right. And then in Greenspan, which we also cited, the court held that the judicial function is to determine intent. So the court can even depart from the ordinary meaning of the words if that's the best way to get a drafter's intent. We don't think you need to do that here, but I just wanted to note for the court that we disagree about how to do it. So we think the way to do it is to look at the words and to look at the intent. So if we just look at the word intentionally, when the ABA model rule got to the Jordan Committee, there was no intent requirement at all. So the Jordan Committee, according to the Board of Governors notes, completely rewrote proposed Rule 3.8 rather than accept the ABA model rule because they believed the ABA version didn't reflect any real world understanding of the criminal justice process. That's what the board said. So the Jordan Committee rewrite added intentionally to in some way reflect the real world understanding of the criminal justice process. So our first argument about intentionally is as the court recognized in Klein, the word was actually taken from the ABA standards, where it was defined to mean acting with the conscious objective or purpose. So our first argument about what does intentionally mean, why does it mean acting with the conscious objective or purpose? Well, that's what it meant in the place where the drafters took it.
Right, I guess I haven't heard the response yet to the opposite interpretation, which seems a little bit more straightforward, which is yes, a purposeful and conscious intent not to turn something over. What is that something? Well, something that you knew or reasonably should have known was exculpatory. And I guess I haven't yet heard what you think that reasonably should have known language is doing in the rule under your interpretation.
Sure. I think the kind of first point I would want to make about that is I really think it's two separate inquiries. So we're used in, for example, in criminal statutes, we're used to kind of an introductory phrase and a colon, and then an A and a B that are different elements of the criminal violation. So I think knows or reasonably should know that the material is Brady is one element of the violation under the rule, right? The other element of the violation under the rule is intentionally fails to disclose. So we actually, there's only so much that fits in an appellate brief. We're not arguing here about the first of those two elements. We're not arguing about whether they reasonably should have known. We're arguing about whether they intentionally failed to disclose. So,
but then you say, I mean, as I understand your argument, part of it is, well, in order to find that they intentionally failed to disclose, you need to find that they knew it was exculpatory, right? That is the uptick of your bad faith argument, as I understand it. I mean, correct me if I'm wrong.
Well, first of all, Your Honor, the bad faith argument, I don't think our brief used the term bad faith. I know that DOJ uses it, and they'll probably be disappointed that I'm not using it. But no, I actually think that it may well be possible to violate the rule without bad faith, and we can talk about that. But I think we need to come to some sort of...
Can you violate the rule under your interpretation without knowing that the evidence is exculpatory?
Yes, although I think that gets back to the question that you would actually specifically ask. What does knows or reasonably should know mean? So I would take you back to the drafting history to answer that question. I think we can all agree the rule is not perfectly clear on its face. The question is, what were the drafters getting at? And I think it's pretty clear from the notes what the Board of Governors were getting at when they put that language in. So this happened in two stages. The Jordan Committee added intentionally, and we haven't yet gotten to what I think they were doing when they put that word intentionally in. But then later, the Board of Governors added knows or reasonably should have known. So let me start with what I think the Board of Governors was doing and why I think I know what it was doing.
I mean, I hate to interrupt, and I do want to hear that answer, although I just first want to understand at a very basic level, how could one, under your interpretation, violate Rule 3.8E without knowing that the material is exculpatory?
Well, I think the main way that that one could have violated it was fixed by the Board of Governors adding of the phrase. Okay, so what the Board of Governors was trying to fix is what I call the 20/20 hindsight problem. If the prosecutor does the absolute best that the prosecutor can do under the laws that exist at the time of disclosure, determines that it's not Brady material, doesn't turn it over, and then is reversed on appeal. Under the Jordan Committee version, information known to the prosecutor that tends to negate the guilt of the accused, that would actually, the reversal on appeal would actually create a disciplinary violation because the information was known to the prosecutor. The prosecutor just didn't know under the Jordan Committee formulation that the material was actually Brady. So what the Board of Governors said was, well, we could fix that by changing the tense. If we change the tense to information that the prosecutor knows at the time, it takes care of the 20/20 hindsight problem. Basically, if there's a later change in the law, well, it wasn't something that the prosecutor knows at the time to be Brady. But if they'd stopped with knows, it actually would have created an ignorance is an excuse problem. So if the rule read information that the prosecutor knows tends to negate the guilt of the accused, the prosecutor could just say, I don't keep up with developments in the law of disclosure. I didn't know it was Brady. So what the Board of Governors did was say information that the prosecutor knows or reasonably should know was Brady. So now I'm going to answer your question. How could you violate the rule without bad faith? I
Without
think
no,
that-
without knowing that the evidence is exculpatory.
Okay, so I think there's actually a very straightforward answer. Suppose you're handed a stack of papers, and in that stack of papers, you know there may or may not be exculpatory information. You throw it in a drawer, and you never look at it again. You have no idea whether it's Brady. I think that might violate the rule. That's not our case, because in our case, lots of steps were taken to try to determine if it was Brady. But, you know, I think the Department of Justice would say, well, that's bad faith. It was bad faith to not even look. I don't know if it was bad faith or not, but I know that knows or reasonably should know holds you as a prosecutor to making a reasonable effort to know. I would read it as knows or with reasonable effort would know. So
I think, I mean, didn't we say in Vaughn, as to the disciplinary action that Miss Officer Childs had, I think, according to the OIA report, falsely filed, that this was not a hard issue, that this was exculpatory under any way you slice it. And so why do you say, so why is that outside the rule under the formulation you just gave me? I mean, what,
So
as long as you keep up abreast of the law, you can unreasonably apply it, and that's fine?
No, that takes us back to the point I made about the two different elements. So Your Honor is going to the element, should they reasonably have known? And I'm going to stipulate for purposes of this appeal that the answer is yes. They should reasonably have known. I want to go to element number two. Why was element number two is, was that information intentionally withheld? Did they intentionally fail to disclose? Intentionally means something. And again, I think from the drafting history, we know what it means. And I think I even know why it means what it means. So I think what it means is you have to have the conscious objective or purpose not to disclose. And I think I know why. Because if you picture yourself in the shoes of the Jordan Committee and the ABA model rule comes to you, and you now picture, let's just assume a situation where the prosecutors do the absolute best job any prosecutor in the world could possibly do to try to figure out whether the information is exculpatory or not. They're all gathered together in a room. They have the case law. They do their best to figure it out. And at the end of the day, it turns out they're wrong. Okay. Basically, they get reversed on appeal, like a trial judge who does a great job in a case, but gets reversed on appeal. Under the disciplinary counsel's reading of the rule, where intentionally only means knowingly, those prosecutors who spent 2 days sweating in this room, trying to figure out as best they possibly could, whether that was Brady or not, they only disclosed what they intended to disclose. They only disclosed, that's sort of the board's formulation. In that situation, those prosecutors actually commit an ethical violation, not because they were negligent, but because they were wrong. And if you read intention.
I don't understand how that tracks. I could absolutely understand if there was a change in the law or a nuance of Brady that was not clear, then the prosecutor did not know, nor should they have known at the time that they intentionally did not turn this over, that doing so would be a violation of their obligations. But here, I think everybody agrees, it's pretty crystal clear that this was classic Brady. And so I don't understand how a hypothetical situation where the law is kind of not clearly established, right, to put it in 1983 terms, could come back to bite them, as opposed to here when I think you've already agreed that they reasonably should have known that this was Brady and they intentionally handed over some things, but not this.
So this is why I was talking about the conduct I was talking about at the very beginning. I think that the question, so if we sort of set aside element one, and say they reasonably should have known, the question is, did they intentionally fail to disclose? And I think the way that you answer that question is by looking at the entire mosaic, as Klein said, of respondents' conduct. What did they actually do? In Klein, the answer is nothing. It was an easy case in the sense that, when you're looking at the entire mosaic of Klein's conduct to figure out whether he intentionally failed to disclose, it's really an intentional failure to act case. And the court said, we're going to treat intentional failure to act cases as intentionally failing to disclose.
So let me give you a hypothetical that I think gets at my concern. So let's say DOC has turned over 3 pieces of damning evidence. The first, the prosecutors look at and they say, wow, this is Brady. Let's hand it over. The second, they look at and say, wow, this is Brady, or it could be Brady, or maybe it should be Brady, but I don't think we need to turn it over. And that's objectively unreasonable. The third falls under the seat of their car and they forget all about it and they don't turn it over. It seems to me the second piece of evidence was intentionally not turned over. The third piece of evidence was not intentionally not turned over because it was inadvertent. And if you agree with that formulation, I would like you to explain why the evidence here doesn't fall into that second bucket.
Okay, so what happened here is a series of actions were taken, culminating in the use of what the hearing committee called the accepted practice at the time of disclosing the underlying source material to the court and giving the court a summary and asking the court to ensure that the summary was adequate. So basically, even the board here agreed, Judge Morin testified that this process was commonly in place at the time, and so on. So our argument here is that if you look at everything that respondents did, what they did culminated after doing a lot of other things too, seeking advice, getting guidance from
I appreciate that, but if I could take you back to my hypothetical, do you think that in the second bucket of evidence was intentionally not turned over?
I think on the facts here, the hypothetical would have to be, they at time A decided that second bucket of evidence shouldn't be turned over, but then they employed the accepted practice of going to the judge and asking the judge to check whether they were right or wrong about that. I think once they employ that accepted practice of asking the judge whether they were right or wrong, they've demonstrated their intent to disclose. They've demonstrated their intent to comply with the rules. So basically, I don't think the hypothetical is a very interesting issue that might come up in another case, but here, the entire mosaic of conduct.
I take that. I mean, I am troubled by the fact that they purportedly attempted to fax the entire report and it did not arrive. But I guess I'll see you that and raise you, their motion in limine did not adequately or fairly characterize that report.
Right. So again, that's the whole point of the process at the time, right? The process that was accepted at the time is you write a summary, and it could be a terrible summary. It could be the worst summary ever written, but you give it to the judge with the underlying source material. And you say, Judge, if there's anything in my summary that should be disclosed that wasn't, I want you to make sure it's disclosed. As long as we follow the hearing committee's findings of facts here, that shows your intent to disclose. The rules about your intent.
Can that really be, I'm sorry I keep interrupting you. There's a lot of questions here, but let's say you file a motion to eliminate that says the exact opposite of what the underlying report says. Are you really saying that there's a safety valve as long as you attach the report that is absolutely damning and proves that what you said was not correct, then everything's frozen?
I think we need to view it through the lens of the real world, right? These were prosecutors who regularly practiced before this judge. This was a judge who specifically testified. Respondents were acting in the spirit of Brady with no indication of dishonesty or lack of candor at the time when they provide the underlying materials to the court. He said it was not unusual in the government at that time to submit, not just in this case, but in other cases as well, materials that they wanted me to review and determine. And then the board said, the board was not going to reach a conclusion that these prosecutors should be faulted for following the court's practice. So I'm saying to you that as a practical matter, Your Honor, if you picture young prosecutors who appear regularly before a judge and they write a summary of materials in a report that, they think captures what needs to be disclosed. It could be a terrible summary, but I'm saying that they're demonstrating their intent that the process that was accepted at the time that would result in full disclosure under the rule was going to occur. And that's what happened here. They did a whole bunch of things that demonstrate their intent to achieve full disclosure. Now they didn't, and that's what disciplinary counsel is focused on. I just want to be clear, the rule that disciplinary counsel asking for here is not a negligence rule. They're saying if you sit around in that room, negligence is a process issue. Negligence is whether you measured up to a standard of care. If they sat around in the conference room for days and they went above and beyond what any prosecutor could ever be expected to do, but they're wrong, disciplinary counsel's argument here is we're going to interpret intentionally to just mean, if you disclose what you meant to disclose, that's intentional. If you're wrong, then you reasonably should have known. That's not negligence. That's strict liability. That's like saying to a trial judge, if you tried your best to get the answer right, but you were reversed on appeal, that's an ethical violation. It's exactly the same thing. And we're just saying that's not what the drafters were trying to get at here. The drafters were trying to distinguish between situations where prosecutors, do their job as well as they can do it, and situations where prosecutors have the conscious intent to thumb their nose at the rule. And I'm saying to you, Your Honor, that in this case, there was no thumbing of the noses. There were mistakes. There were junior prosecutors who got things wrong, who didn't do things that they should have done. There were errors.
May
May I ask you a question about that?
Of course,
One
Your
thing
Honor.
that struck me about the report is the way that they phrase the finding on intentionality and what they don't say. So suppose I ask the following question. For what reason, what was the actual factual reason that the two prosecutors here did not disclose in the motion in limine the fact of the false report, the false disciplinary report made against the inmate?
So there's extensive testimony in the transcripts about that. And the actual factual reason was that Ms. Dobby, who was drafting the motion in limine, thought that, the important thing about the investigators' reports was its findings. And she started with the findings, she put them in her summary, and then she went looking for the facts that related to the findings. So she simply made an error. It would have been, she should have also disclosed the false disciplinary report. But the reason that she didn't disclose was that she had a process. Her process was, what's the conclusion? What are the conclusions of the report that relate to this government witness? What are the facts that you need to know to understand those conclusions? I'm going to put them in the report. And Your Honor, if you read the transcripts, and I'm sure the court has studied them, one thing that comes through with great clarity is that what everybody involved at the time on the prosecutor side thought was important was sending a signal to the defense that there was a Giglio issue here, and getting the materials in front of the judge so that the judge could be darn sure that everything that needed to be disclosed was disclosed. Now, they didn't achieve that, but everyone agrees that they didn't achieve that because of an error. And I'm saying that the rule here is about their intent. We're focused now. I concede, Your Honor, that these things that you would have liked to seen in the report should have been in the report. What I'm saying is, the intent to disclose those things was clearly demonstrated by writing a summary, an inadequate summary, but a summary, sending that to defense, signaling to the defense that there was an issue, and going to the court and saying, Your Honor, if there's anything in my report that additionally should be disclosed to the defense, the government is requesting that. And that's.
I asked you that question because that is pretty much how I understand what happened here. And I don't see that anybody has argued otherwise. And it seems to me that there was no deliberate decision, no purposeful decision found on the part of either respondent to omit the information about the disciplinary report.
Right, and in fact, you're,
Instead,
yes.
and instead, and if that's true, it does seem to me as if they made a mistake. They were blind. They simply missed it. They read the whole report and somehow came to a different impression. All those things are true. It is true that they should have known that this was Giglio information of some importance that needed to be disclosed. And they just missed it. And they made a mistake. And you could say that they were sloppy. They blundered, they pick your adjective. But I don't see, the question is whether that kind of mistake equates to intentionally. And what the board says is peculiar to me. What the board says is, I'm more or less quoting, respondents intentionally filed the motion that did not contain this disclosure, and therefore it was an intentional non-disclosure. And that is the board's reasoning, in my opinion.
Yes.
And they say it more or less twice and sometimes in different words, but that's basically what they are saying. And I don't see that as an intentional non-disclosure of the information.
And just to kind of
If they
put
had it
on
in
my,
front of, if she had it in front of her, Pistabi say, and she's writing this draft, and she says to herself, well, should I include that information or not? No, I won't include it. That would be an intentional non-disclosure. But I don't see that any finding has been made, unless I've missed it, that there was that kind of intentionality.
no, Your Honor. And actually, I want to just point out, well, two things. First, I think to capture the distinction that Your Honor is getting at, I think it is actually helpful. This is sort of my geeky legal hat, but I think it's helpful to distinguish sort of what I think of as the meaning of the word intentionally from what I think of as the meaning of the word knowingly. Because what Your Honor described, sort of, they were aware of their conduct. That's knowingly. You know, that is a term that was also defined in the ABA standards from which the drafters took intentionally. And if what the drafters had meant was knowingly, then they should have chosen it. But I think, again, to just go back to the real world, that choice has a huge impact. If we read, this is not our fight because we don't think that the respondents in this case either intentionally or knowingly failed to disclose, because what they knew, their actual knowledge about the process that was in the practice at the time, their actual knowledge was, if I write a summary and I give the underlying source materials to the judge, the things that, you know, need to be disclosed will end up being disclosed. So I think we win this case on either intentionally or knowingly. But the distinction matters a lot in the real world. In my example of the prosecutors who work hard for days in the conference room, come to the wrong result, but using all the diligence in the world, you know, those prosecutors would violate the rule on disciplinary counsel's understanding of intentionally. If all it takes to be intentional is to not hand over things that you decide don't need to be handed over. If
That's not, counsel, I don't think that's the record that we have. And I wonder if I can just direct your attention to see what your response is to footnote 10 of the board's report, which I think is quite, you know, I'm pointing you to a footnote, but I think the gestalt of it is all over the board's report and the hearing committee's findings. What footnote 10 says is that the respondents don't contend that they forgot about the information or that they had, you know, mistakenly omitted it from their summary. They, at least Respondent Taylor, admitted that they didn't report it, that he had falsely accused another inmate of assaultive behavior. And to be clear, we recognize that this was Brady material. I don't understand what more, you know, once you have, we know it was Brady. We knew it had to be turned over. We didn't turn it over. I don't understand what other thing is missing in your view to form intentionality. You know, and it's not a mistake. It wasn't inadvertent. We didn't forget about it. It wasn't, I mean, which makes me kind of a little hesitant to adopt they made their best efforts spin on things. What's your reaction to that part of the board's report?
So I think that part of the board's report is mostly about the first issue. Should they have known? And again, we concede that they should have known. We're saying this was not just Brady material, but material that the respondents should have known was Brady. Now I want to shift over to the question, what does it mean to intentionally fail to disclose? And I'm saying you can't intentionally fail to disclose if you follow an accepted practice that's in place at the time that is designed and intended.
I'm sorry, was the accepted practice from Judge Morin's view that anytime somebody had what they believed to be Brady material, they would turn it over to the judge and ask the judge not to turn it over to the defense unless they really thought it was extra Brady? Or was the accepted practice that prosecutors would routinely turn things over that they knew to be Brady? And when they thought it wasn't, they would turn it over to the judge and just for a safety valve. I mean, those are two very different practices. And it sounds like you're talking about like it's the first one, but I don't think it's the first one.
Well, I mean, I think so this, I think, is another one of these meta issues in this case that's very important. I think that the record in this case is the factual record that the hearing committee created. There are times when you can deviate, right, from what the hearing committee finds as fact. And this court has described how you do that. If the court has described that both the board and this court are required to defer to the hearing committee findings unless they're not supported by substantial evidence. And if the board or the court is going to make a finding that's contrary to what the hearing committee said, of course, it would also need to say, and we find that disciplinary counsel has carried the burden to show by clear and convincing evidence sort of the opposite of what the hearing committee found. But what the hearing committee found is in finding of fact 35, found that what actually happened here in this case was that respondents disclosed the source material to the court ex parte and summarized it to the defense for a determination whether the summary was sufficient or additional information should be disclosed. And the hearing committee found that that was the accepted practice at the time. So the answer to your Honor's question is, don't take my word for it. Basically, we know what was going on in this case because the hearing committee's findings of fact govern what was going on in this case.
The accepted practice, if I read the hearing committee's report again, you're telling me what I'm going to see is they're going to say, when the prosecutor knows something to be Brady, the proper course of conduct is to turn it over to the judge with a motion in limine that suggests they don't need to turn over the source material. That would be Brady in their view. And just to clear it, I don't recall that bit of testimony. I don't recall that hearing committee finding. I mean, I understand that.
No, Your Honor. I think, though, that there's a kind of key distinction between this case and your hypothetical, right? Your hypothetical was when a prosecutor knows something to be Brady, et cetera, et cetera. Here we're stipulating that we're talking about relatively inexperienced prosecutors who made mistakes. And
I'm still quoting from footnote 10, counsel. We recognize that this was Brady material. That's an admission.
Can you reframe your question then? Because I didn't get a question.
Yeah, maybe I heard your response to me was going to be, well, they might have made a mistake. You're going to distinguish my hypothetical because I'm positing that the prosecutors knew it was Brady material, and in that instance, it wouldn't be appropriate to turn it over to the judge.
No, actually, respectfully, Your Honor, I was going to say that I think what you're positing is some version of bad faith. I think you're positing. So this is kind of the point of the PDS brief, right? The Public Defender Service is essentially the narrative of their brief is these were prosecutors who knew darn well that stuff should have been turned over, and they sort of manipulated and schemed and managed somehow not to turn it over. The problem with that is it's inconsistent with the findings of fact. And I'll just give you one concrete example of that. A big issue here, and I think this relates to Your Honor's question, a big issue here is the board and disciplinary council and PDS all think that respondents should have disclosed not just child's demotion, but that the demotion was the result of a false report. That's sort of the centerpiece of a centerpiece of the PDS brief. And it's kind of part of a narrative of these were scheming prosecutors. Well, the hearing committee expressly addressed this. There are findings of fact. The committee said, the committee does not know even today what the facts are concerning child's demotion. If ODC thought it was important for the committee to know the reasons for child's demotion, we assume it could have subpoenaed child's personnel record. Be that as it may, the committee has not seen them and has no basis for finding that Childs was demoted for excessive use of force or for making false reports. And we can't ascertain whether his testimony was false, let alone whether respondents had any basis for correcting it. The people who saw these witnesses—
I mean, counsel, you're just pivoting to a slightly different point about whether or not how the demotion was tied to the false disciplinary report. But you're still not addressing that respondents, or at least Taylor, I believe, has admitted that the fact of the false disciplinary report, they knew to be Brady. They knew they didn't turn it over. It wasn't inadvertent. And I don't see how any of your responses—
I don't think there's any— respectfully, Your Honor, I think in the hearing, there was discussion of whether, sort of with 20/20 hindsight, do the— it's sort of like an indication of contrition. Do the respondents accept that these matters were Brady? Absolutely.
Mr. Simeon, that's not how I read that portion of the transcript. This concerned me greatly, and I spent a lot of time rereading what Ms. Taylor said there. She was pointed directly to the disciplinary report. She said, we knew about it. We knew that was Brady. She spoke for Ms. Dobby there in effect too, but
we knew at the time.
we knew at the time. I read her as saying we knew that was Brady material.
I respectfully, Your Honor, I don't read it that way. If you could point me to a place I have the transcript, that'd be happy.
252, right?
I forget what the final number is. Can you get it? Because I cannot do two computers at once, frankly.
Yeah, I think we're talking about, I think we're talking about the past tense we recognized. This is at page 254 at the top. To be clear, we recognize this was Brady material, but there is a difference here between Brady that was strictly exculpatory. Somebody else did it, and I'm not sure where it's going from there. But I think that's what we're highlighting.
And if you read the paragraph or two before that, she is referring directly to the disciplinary report.
So I'm sorry, Your Honor. I can't. I don't have time to sort of coherently answer that question, because I'd have to process what came before and after. But I think that our point is, I think this takes us back to what Judge Deal was asking about. Our point, we're willing to concede that it was Brady. We're willing to concede that they should have known it was Brady. And knows and should have known are no different, under the rule. If you're pointing out to me, well, maybe she knew it was Brady. Okay, that's element A. Now the question is, I think Judge Deal's question was, is it my contention that you also still have an argument under element B? Does disciplinary counsel have to show that they intentionally failed to disclose it? And I'm saying, yes, my contention is it's not just that they knowingly failed to disclose it, which is what we've been talking about, assuming that they knew it was Brady and they didn't disclose it, they knowingly failed it. I'm saying they followed a process that was accepted as the process that in the end would result in all disclosures being made. And I think Judge Deal was skeptical, sort of like, were they abusing the process? Were they trying to end run the process? And I think that I think that the findings of fact in this case answer that question. The hearing committee specifically found that they weren't doing that. The hearing committee found that they didn't set out to violate Brady Giglio with deliberateness. So unless there's, unless there's no substantial evidence in the record for the conclusion that they didn't set out to violate Brady and Giglio with deliberateness.
Mr. Simeon,
What
I want to
situation-
take you back to a question that Judge Deal had asked,
Sure.
and I'm not sure that there was an answer. If I missed it, I apologize, but it seems like there are two potential processes here. One is you can disclose this to the court and say, is this Brady? I need help. I have toiled away and I can't figure it out. Or there was the approach that was taken here, which is to file a motion in limine, expressly trying to keep the information out, expressly telling everybody involved that this is not Brady, and then just appending ex parte the report so that if the court wants to do some extra digging, he can, assuming he has the full report, which he does not. So which approach are you saying that these attorneys followed, and which was the accepted practice?
So I think that does go to Judge Deal's question. And I think that Judge Deal, I think that Judge Morin answered that question in this case. Judge Morin testified that he knew exactly what was going on. Judge Morin's view was that what they were asking him to do was ensure that anything that needed to be disclosed was disclosed. And again, of course, we know from the findings of fact that Ms. Dobby expressly asked in open court that if there's anything in this report that needed to be disclosed, additionally that needed to be disclosed, the government is requesting that. So I think in answer to your question, Your Honor, they were doing exactly what the accepted practice was, which was getting the source materials before the judge, asking the judge to ensure that anything that needed to be disclosed was disclosed. And my argument is not that that sort of absolves them of any mistakes that they made about what material should be disclosed or whether it should be disclosed. My argument is that that shows that they had in their heart of hearts the intent that material that needed to be disclosed should be disclosed. Maybe I could try to answer Judge Deal's question another way, which is to say, going back to Klein and sort of this notion of the entire mosaic of conduct, if you just take a snapshot in time, a point along the axis of time, and you say, what was their intent right at this particular second? You could have a prosecutor who looks at a document and doesn't think it's Brady, doesn't turn it over. 3 days later, they look at it again, they think it's Brady, they turn it over. I'm just saying that this was the same kind of continuum where, they made some mistakes, they made a judgment, lots of things happened, but the end of that sort of, entire mosaic of conduct was they said, you know what, we're not going to do what Klein did and not even bother to ask the judge. We're going to employ what's now the accepted practice. We're going to make sure that the judge signs off on what we've done. We're going to give him the source materials and make sure that anything needs to be disclosed is. And I'm just saying that doesn't mean that they got it right. That means that they had the intent to get it right. And that's what the rule requires, unless you interpret intentionally as only requiring knowingly.
On this question,
problems.
on this question, if I may, it segues into the question of the board's dishonesty determination, this question of intentionality. The board found that the omissions from the motion in limine were violations of 8.4 C, I guess, dishonesty. And the dishonesty finding is based on a determination of recklessness, which the board defines as conscious disregard of a known risk. Do you want to speak to whether the evidence supports that determination of conscious disregard of a known risk. If they consciously disregarded it, then it's very tempting to say that that's equivalent to intention.
Thank you, Your Honor. Yeah, I think that my kind of core point here is the one that I really started the argument by saying, which is, we think that their conduct is the key, and that as to all the rules, it shows that they didn't have the required intent. And here, the key piece of conduct is the same. So if the question under this court's cases is, did they consciously disregard their obligation under the rule to disclose everything that needed to disclose? Did they just not care whether it got disclosed or not? I think on the factual record here, that's an extremely easy question to answer. Of course they cared. They wouldn't have gone to the judge, supplied the source materials, and stood up in court and said, Your Honor, we want to be sure we didn't get this wrong. Could you please make sure that anything additional that needs to be disclosed to the defense is disclosed, if they didn't care? It's the same inquiry. And that's why I think that on the factual record here, the hearing committee that had the opportunity to hear the testimony, see the demeanor of the witnesses, that committee was convinced that there was no deliberate, there was no indication, of chicanery. They just thought that the law obliged them to come out where they came out. And I'm saying, no, the law is, under this court's precedence, the law under Rule 8.4C is, just as Your Honor put it, was there a conscious disregard? Of course there wasn't a conscious disregard. Ms. Dobby stood up in open court and tried to ensure proper disclosure. I would say the same thing very briefly about Rule 8.4D. This court's cases generally require either intentionally or consciously interfering with the administration of justice, an intentional disregard for the consequences of one's actions. Now, we acknowledged in our brief that there is a case in Re LR that predates the intentional disregard standard that talks about recklessness or somewhat less blameworthy. But we think that that's been supplanted by the more recent, more clear, more sort of comprehensible intentional disregard standard. But even if it isn't, this case is nothing at all like in Re LR. That involved a violation of an express statutory ban on taking money from a CJA client. And I think that shows both conscious disregard for the consequences of the conduct and a motivation for personal gain that are both absent here. So I just want to.
And do you want to speak to aggravated neglect? As long as we're on the subject of lesser states that seem to fall within the category of intentionality.
So this is actually where I had hoped to sort of start the argument by distinguishing Klein. I mean, I think first of all, Klein itself, I would call I would call Klein an intentional failure to act case. Okay, so it cites the intentional failure to act cases from the Rule 1.3 context. Because if there's a sufficient pattern of neglectful conduct over a long period of time, we can infer from that you're not taking seriously your responsibilities under the rule. You're intentionally violating the rule. But Klein said, not for application in that case, because it wasn't applied there, but Klein said, there's another way that you might be able to show intentionally through aggravated neglect. If there were, putting aside a case where you didn't act at all, which was Klein, it just was a complete failure to act, you could have a case where looking at the entire mosaic of conduct, you come away convinced that the intent was not to honor the obligations under the rule. And as to aggravated neglect, my submission here is it just doesn't apply because this isn't a failure to act case. They acted all over the place and they their final act was to go to the court and ask the court to make sure that they hadn't under disclosed. And I'm saying, the aggravated neglect has no place in this case because it's sort of another way to show intent. We don't need another way to show intent. We know what their intent was. We can directly see into the mind of the respondents here, unless you sort of discount the hearing committee's findings that when they said that to the judge, they meant it. I know I'm way over my time, but I'm happy to stand here all day and answer questions.
No, we're not going to keep you there all day. We're going to hear from Mr. Little, but we'll give you a brief period for rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Alex Little on behalf of Respondent Taylor. I want to start first with Judge Deal's question about that footnote in the board's decision. What I'll say is the board did not get a number of facts right. As you know, they posited that there was no disclosure ever of the fact that he had been actually of the demotion at all, when of course that was disclosed before trial. This footnote is not as sort of an egregious a factual misstatement, but what it relates to in that whole scope of testimony actually starts way back on basically 249. And what's happening is disciplinary counsel is asking my client about the disclosures related to what's characterized as a false report and whether or not that should have been disclosed. The whole context, it's a whole week of testimony. And so what this is about is there is a distinction that was made both within the U.S. Attorney's Office and with the respondents in discussing it about Giglio information and kind of what they considered true Brady. So that sentence that you read, Your Honor, about that this wasn't strictly Brady meant they were talking about Brady as to a particular element. When she used Brady in that context, she was referring to Giglio, and you can tell that by the very next sentence where she says Childs wasn't there that day of the event. The first question we had to decide is, how is this whole Lewis process started? Do we even call Childs? Because if they don't call Childs, it's not Giglio, it's not subject to disclosure. And so in the time that she's talking about, that's when they started the Lewis process. They later get to disclose and litigate guidance. And so there certainly was not a finding at the hearing committee based on the whole sort of atmospherics that knew the context of this, that my client knew that she had Brady information that she should have disclosed and did not. Had there been a factual finding to that, we would have appealed it. And the appeal of the board, there's certainly not a factual finding about it. And I think that's where we come out on that. This is not a case where these two individuals knew that the stuff they were supposed to disclose, they didn't. They intentionally tried to withhold it. And I think co-counsel has addressed that very, very well. I do want to talk about the importance of the process that was used here. I know Judge Ali Khan had some questions about that. There is a decent amount of record information about it. But the process that was used, there certainly is no distinction when you kind of take it the 1,000-foot view between what the prosecutor's state of mind is when they give information to the judge. Because there are circumstances under the safety valve where you would provide known Brady to the judge and convince the judge for some extra reason that should not be disclosed. It happens in the national security context, victim safety contexts. And so the purpose of the safety valve is to allow even those circumstances when there is, quote, undeniable Brady to be withheld in certain circumstances. I'd say the more common use of it at the time in DC Superior Court, and this is consistent with Judge Morin's testimony, is on close calls or questions about what should we do, the information is provided to the court. And I'll reiterate this aspect of our brief. There is no case in the country, in a disciplinary case involving prosecutors, where a prosecutor has actually disclosed the relevant information to the court and later been found to have committed a violation. There are two pieces of information at issue.
When was the disclosure of the false disciplinary complaint disclosed to the court?
I think they all believed it was disclosed in the fact.
I see. I mean, that's not quite what you said, though. You said there's been no case where it was disclosed to the court and it's found.
Well, Your Honor, I mean, I think you'd have to find then that this is a case where they don't get the benefit of doing what they believe they had done for accidental reasons. And I don't
know if I have to find that. I might just think that if you're going to hide the ball on critical evidence, you better be dang sure that you pass it over to the court. And if you fail, that might be something that it's not in the summary. It doesn't make it to the court. The advice from the Lewis Committee was to disclose, and that didn't happen. I don't know why I would have to find anything other than this was something that they intentionally didn't turn over. They were hoping to sort of get the court's opinion to make sure it was okay, and they failed to get an informed court opinion by failing to turn this thing over.
Your Honor, I think that would eviscerate the sort of intentionality aspect of it. I mean, you can have circumstances where you don't have to disclose anything. There's nothing in the rule that says there must be disclosure to the defense in this sort of context. And so I think what's difficult about that hypothetical is they could say, we're going to fax this to the report. We're going to disclose it to you, Judge. We're going to ask that you keep it under seal. We don't think it needs to be Brady. Half of it gets to the court. They don't make any summary of it at all. The judge says, I'm going to keep it under seal. I'm not going to disclose it to the other side. And that they would then, because of an accident, be held liable under that theory for an ethical violation. I don't think that comports with both the rules nor their purpose in governing sort of intentional
Do you not see
misconduct.
something extremely troubling about that scenario? I mean, you know, this was something that was brought up at one point during during the hearing by Mr. Fox. If you don't give the defense some sort of fair notice of what's at issue, it's really an unfair litigation. And you're putting the judge in an awkward position, but you're getting an unfair advantage over the defense in trying to persuade the judge that the material should not be disclosed. That doesn't trouble you at all?
Your Honor, it is troubling in that context if there was the intent. I think here there's no intent that was found. In fact, the intent was the opposite that was found by the hearing committee as to what the intent of these two prosecutors were. There may be scenarios in which prosecutors were found to act with that sort of malintent, but that's certainly not the case here.
You said that the court, I'm just looking at 3.8E again, and the prefatory language is intentionally failed to disclose to the defense.
Mhm.
You just said something that suggested to me that you think the prosecutor thinks something is Brady material. They're always unfair. It's always fine if they pass it through the judge and say, Judge, here it is. You have a review at it. And if you think we have to turn it over, we'll turn it over. Is that compliant with 3.8E?
I think at the time, that was the practice. And that was a practice.
I don't think it was, counsel. And if you think it is, I really need you to point me to the hearing committee testimony. I mean, I assume you're going to point me to Judge Morin's testimony. But I don't
Yes.
recall anybody saying
Chris
something
Allen,
is fairly Brady. Not like when I'm not sure. When something is Brady, and we've said in Vaughn that this was not a close call, that you can take a crack at the judge first before disclosing it. See if, maybe the judge will say it's okay not to disclose.
No, Your Honor, you're correct. There's no record evidence to that point because it wasn't relevant to the facts here, because there was no sort of, I think, even argument that was where we were. The argument that was consistently found in the testimony, and I think both these respondents testified, they were credited as to their testimony, was that they were doing their best from the jump to figure out how to handle this. And I think to take that out of that context would be to place emphasis on that in a way that really isn't consistent with what the hearing committee found. At every step, they said, what should we do? They were given guidance. In fact, the main supervisor there, Jeff Ragsdale, testified that they, put this under seal and do it the way that they did it. The hearing committee ultimately found that was, they credited that testimony, and that's what these respondents did. And when asked about that scenario, Judge Morin was very consistent that is common in his courtroom. And so
did anybody look at the summary that they wrote and say, this looks good to me?
Supervisors, I don't think there was testimony that supervisors had seen that, no.
And wasn't the sample motion in limine that Ragsdale turned over, hadn't it contemplated that the report was turned over to the defense? I must be getting that wrong. That can't be.
No, you're right that draft, they did turn it over, but Ragsdale testified in this circumstance that he thought they could put it under seal.
Mr. Little, wasn't there a finding that no supervisor reviewed the motion in limine? I think it's finding 41.
Yes, and I just said that to Judge Deal. There's nobody had reviewed the summary, but it was provided by Mr. Ragsdale with the direction to put the report under seal.
One of the things that's confounding about this case is why on earth Mr. Ragsdale and others, I guess, thought that there was any reason to put this under seal and give it to the judge. The whole process, I don't fault the individual assistants, Darby and Taylor, so much for this, but the guidance they got from their superiors what's another word for confounding? Hard to understand.
It was hard to understand, Your Honor. It's an
In
issue we
retrospect, at
raised.
least.
We brought that up throughout the proceedings because it went to their good faith. It went to the decisions they made and whether their actions were intentional of the type that were subject and should be subject to discipline. But I do think it is important when you're putting yourselves in the shoes of a first year, second year line prosecutor in a case like this, who has obviously, based on that record, not a great deal of supervisory attention, even though they've made affirmative efforts to take this issue to the supervisor. And one of the safety valves that they try to rely upon is giving the report and believing they've given the report to the judge. And then Respondent Dobie even asking later, judges, if there's anything in there you think we need to provide, please provide it. All of that is done. And I think it all reflects on the intentionality that they are trying to make sure they uphold their obligations. And in this way, this case is far afield from other Brady cases where prosecutors either have intentionally, and there's evidence they've said, I don't want the other side to know this, or through some series of negligent actions, turned a blind eye to not doing steps they should have taken, knowing that they were hiding evidence in the process. This case is nothing like those things. And I think that's why the hearing committee findings are so maybe unusual based on what the ultimate legal conclusions were. And we've now looked at, I think, very different legal theories for how these two individuals have violated Rule 3.8 at each level. There is a different theory.
Could you remind me, just because we're touching on the interaction with the judge, what were the hearing committee's findings about the moment in the court hearing where the court says, wait a minute, this doesn't look like the full report? Counsel, what about that? I have no findings in this report. And the reaction is, oh yeah, 5 pages is all I have as well.
I don't have the exact paragraph.
I'm paraphrasing.
But generally it was an honest failure to recollect that there were more than 5 pages. I think both of them at that time, my client testified about that as well and said, I don't recall exactly.
But it's weird. It's weird. I mean, again, we're stuck with the findings that we have, but it's odd that the sort of defense to this summary is, well, we started with the findings and worked backward. And then you have the court saying, hey, this report doesn't have any findings. Anybody want to tell me why that is? And they say, oh yeah, mine doesn't have findings either. I mean,
well, I think the way that we use the word findings was different. I mean, I think, the findings the judge is referring to was a findings as to an ultimate sort of conclusion. There were factual findings up in the report that I think were bulleted, which was what previously.
Right, I think they're all talking about the last page of the report. I mean, looking at the Collins report, the final page says, here's 4 things we're finding. Number 1 is lying about the person, the inmate being restrained.
Handcuffs.
And then he said, and then he doesn't refer to Mr. Childs when he talks about the false report as to an assault on the canine. He only talks about the only 2 officers. That's kind of what provides, as I understand it, part of your client's explanation, or at least part of Taylor's explanation. I can't remember. I can't keep straight exactly the various explanations, but respondents collectively seem to say, well, that's why we kind of omitted the false disciplinary report because it wasn't included in the findings.
Right.
And then when the court gets it, he says, wait a minute, there's no findings. And I think he's talking about the exact same thing, the conclusions of the report. This report doesn't have those findings. And I only have 5 pages. It's a really strange reaction to say, well, mine doesn't have findings either, if the whole impetus for the summary was, well, we started from the findings and worked backward.
I think, Your Honor, one difference is there's a difference in time. Those are about a week or 2 apart. That's also the second set of circumstances. The questioning of the court was in the middle of the cross exam, I believed, by defense counsel at that point. And so, obviously she took the stand. She was asked questions about this by Mr. Fox, and the hearing committee concluded that her failure to recollect and my client, Ms. Taylor's failure to recollect were credible, that there was a credible explanation based on the testimony they gave. And this was a topic that did come up. They were asked extensive questions about that. And the hearing committee was ultimately quite, I think they came to a conclusion that we believe was correct, that it was an innocent failure to recollect.
May I ask you a question on another subject?
Yes, Your Honor.
And that is the sanction that is recommended here, a 6-month suspension. What is your understanding, if that sanction is imposed, what is your understanding as to the actual practical effect, how that would play out for the 2 respondents, the Department of Justice employees in this case?
Your Honor, I don't know how it would play out with respect to Ms. Doby. My client is still an employee within the Department of Justice. It would have to be reported to them, and then they would make whatever determinations they have to make.
So yeah, and you don't really have any insight into what that would likely mean for her.
I think it would be obvious. I mean, well, one thing, it would be follow her for the rest of her career in a way that no matter what she did after that suspension would be very difficult to find any employment outside of government if the government did not take additional steps as a result of it. It is a horrendously, maybe that's the wrong word. It is an incredibly severe sanction.
Okay.
And so, I'm happy to answer any other questions. My co-counsel did a great job, I think, discussing many of these topics with you. But I do think it's important, if you look at the way this case has evolved from the beginning to the end, the theories as to how they committed misconduct have changed at each step. And it's changed in part because the facts have been so clear that they were consciously trying to do the job right. And to the extent they failed to do that, the hearing committee created sort of a standard that there's all these other things you should have done. But they made clear that giving it to the court was correct. And then at the next level, there was another change as to how this was done. And that, well, as long as you're incorrect as a matter of law and you intentionally do it, then you violate 3.80. And I do want to get to Judge Alicon's question if this is an obvious Brady violation, because there's a little bit different record. This happened 10 years before the hearing. It's been, I think it's 9 years between the trial and when the hearing was done. And there were a couple cases that were critical that came out between the time the trial took place and the Vaughn opinion, and one is Longus. And there's a very long discussion with Chris Ellen Kolb, the appellate chief, about how that decision in Longus affected the thinking both of the office and what they did and how they did it. Vaughn makes very clear that the court believed that this should have been disclosed. But there were reasons that the prosecutors, I think, acted the way they did at the supervisory levels down to the client level. And it was because of the way that some cases had treated Giglio disclosures on collateral matters back in the 2009 time period. And so there is a passage of time issue that was certainly discussed at length. Our briefs dealt with it quite a bit before the hearing committee came out with their conclusions. And so it is not an open shut. They should have done this. Why did 8 people in the Department of Justice and even the appellate chiefs who signed up on the briefs all the way at that time to Mr. McLeese, sign off on these as not a Brady issue. It was because there had been an evolution of the law and it wasn't as straightforward as it I think now should have been. So I wanted to raise that issue in response to the question that you had posited earlier.
Mr. Little, I have one other question about penalty. In response to Judge Lichtman, you noted that a 6-month suspension would follow them. If we were to adopt, I believe it's your co-counsel's argument in his brief, and perhaps find a violation but have no sanction, are those concerns the same?
I don't think they're the same. I think that it will follow in a way, but I think that the extent to which these circumstances are unusual, not likely to be repeated. A court speaks both through its sanction and through its determination. And so I do think that the way that the court speaks to the sanction is relevant, even if it were to find a violation. We don't think there should be a violation because these 2 young women, I know my client from the moment she started this process and thought there was an issue, believed that she was doing her best to follow the rules and to disclose in the manner that she needed to. And if there's no further questions, you all have been very generous with your time today. I'll allow Mr. Fox.
Let us hear from disciplinary counsel.
Thank you all.
Thank you.
May it please the court, Hamilton Fox, the Office of Disciplinary Counsel. We are here defending the board report, and I do want to address the meaning of Rule 3.8E, but before I do that, I want to go to what I believe is a misstatement of the record with respect to the submission that was made to Judge Morin. Nobody ever said to Judge Morin, we have a Brady issue here or a close Brady issue here, which we need for you to resolve. What was submitted, and it's our Exhibit 17, that's the motion in limine that the respondents submitted in this case. Indeed, that's really the crucial document in the case, along with the report. And what this motion in limine did was ask the judge to restrict the use of the fact that the witness, Mr. Childs, had misused force with respect to an inmate and had made a false statement about the misuse of force. And this was rolled up to the judge as a collateral issue. The authority that they cited for that was I'm just double checking here. I think it's Federal Rule of Evidence 608B. That's the Federal Rule of Evidence that limits the use of impeachment information so that you don't get into a completely separate trial on a collateral issue. That was the issue that was presented to Judge Morin. Nobody said to Judge Morin, is this a close Brady? This is a close Brady question. We don't know what to do with it. We want your advice. That was not what was asked. And what they did was they submitted a motion in limine that falsely characterized the report in question. Putting aside for the moment, what I think you can't really put aside, the fact that it didn't mention at all that Childs had falsely accused another inmate of assault. It said there was a statement that he had made of this finding that the Board of Corrections had made this finding about him making an improper report, but it then denigrated it. It said, we are not at all agreeing that that's true, and quoting from a statement that Childs had made, which the report had said was not accurate. They said the evidence could go either way. So this is the issue that's rolled up to Judge Morin. How are we going to limit the use in cross-examination of this information that we've disclosed about this corrections officer using improper force against an inmate and then lying about it? How are we going to control that so we don't have a complete mini trial on this other issue? So the notion that somehow or other there was good faith in submitting this issue to Judge Morin to let him resolve the Brady issues is a fiction. That's not what happened. Now, Judge Morin did testify that the practice at the time in some instances was for close issues, evidentiary issues, to submit them to the judge and let them resolve it. But nobody has ever, there's just no evidence at all that what these respondents did was ask the judge to resolve a Brady issue. Remember, Brady is, the fact that there was Brady in this material is, they knew that going in. Why did they submit the thing to the Lewis Committee? The Lewis Committee doesn't decide whether something is Brady or not. The Lewis Committee decides whether this witness is so damaged by the Brady material or the Giglio material, so damaged that we can't call him as a witness. Now, obviously, if the information you've got puts in doubt the question of whether you're ever going to be able to call the person as a witness in the first place, it's surely Brady material that has to be disclosed. And that's what the Lewis Committee told them to do. Disclose it, meaning disclose it to the defense counsel, and litigate. And what they were going to litigate was the extent to which the information could be used in cross-examination. And, you know, we obviously disagree strongly with the finding that Mr. Ragsdale told them to do it in a motion in limine. But what he told, as I think Judge Deal pointed out, he never supervised the motion in limine. And what was supposed to be submitted in the motion in limine was whether we have to disclose this entire report in order for them to use it in cross-examination, or whether we can just get away with disclosing it the essential facts in the motion limiting. That was the issue in front of Judge Moore. It was not a Brady issue. Now, having said that, let me go to the interpretation of Rule 3.8E.
But Mr. Fox, can I just ask you about how your sort of prefatory comments intersect with the hearing committee's findings? I just want to highlight, sorry if I'll speak up.
No, a word dropped, that's all, I'm sorry.
I just want to square your comments with the hearing committee's findings. So finding number 47, this is paragraph 47. They say, when Dobby faxed the motions to Judge Morin's chambers, which was common practice at the time, she inadvertently only transmitted 5 pages. That to me reads, it's not that faxing was common practice. It was that this was a common way of sort of clearing potential Brady material. Now, maybe the hearing committee is just wrong about that for the reasons that you specify, which is that this was never even flagged as potential Brady material in the motion in limine. But I don't know that we could say that because the hearing committee's report makes it sound like this is how things were done back then based on the testimony that they've heard. Do you have a reaction to that?
Yeah, I do. And my reaction, I guess I have 2 points. One, it may well have been done back then with respect to Brady. But that's not, but in the finding that you read me, there's no reference to Brady material. What they were submitting for the judge, and this was common practice also back then, was the determination in advance as to how far the defense is going to be allowed to go in cross-examining this witness about this information. And I mean, the short answer to you, Judge Deal, is, I'm giving you a work assignment here, but forgive me, is to read the motion in limine and
I've done that.
and read the discussion that was made at the time when when this issue was being litigated in front of the court on the first day of the trial, and there is one statement in there that the respondents rely on heavily, that Ms. Dobie made, to the effect, and it's a phrase within a longer sentence which says, if we're wrong about this, and I'm paraphrasing, I don't have it right in front of me, but if we're wrong about this, please tell us and we'll disclose more. But all of that is in the context of the respondents trying to limit the use of the information that they provided in cross-examination. I'm not sure the word Brady is even mentioned in that colloquy. I'm not sure it's even mentioned. I should probably have gone back and looked at it. I should have given myself this assignment. I'm not sure it's even mentioned in the motion in limine. This was not rolled up to the judge as a Brady issue. And in some ways, I think this may illustrate why the interpretation of 3.8E that the respondents are pushing forward is just incorrect. And I think there are 3 things wrong with the interpretation. The first one is that it ignores Klein. The second is that it's bad English. And the third is that it's bad policy. Let me talk about Klein. Lots of phrases have been picked out of Klein in this discussion, but what I think has been not mentioned is the actual holding of Klein. Remember that the important part of Klein, we all agree, is the determination that Brady and Rule 3.80 are not coterminous, that there's no materiality as to the result aspect of 3.8E. And that was decided in part Roman numeral 2 of Klein. But there's a Roman numeral 3 in which the court says, once we've decided that, we've got to decide whether this conduct, Mr. Klein's conduct, violated Rule 3.8E. And I'm just going to read you the last line of Section 2. And I'm only reading part of the sentence, but I think it's fair. Klein intentionally withheld the statement because he did not think it was exculpatory. Now, there are two things that are important about that. One, he intentionally withheld the statement, meaning, he didn't have, he doesn't say he had intent to act in bad faith or deprive the people of Brady material. It says he intentionally withheld it because he didn't think it was exculpatory. Because he didn't think it was exculpatory was evidence, conclusive evidence, I think, that the withholding was intentional. You don't think it's exculpatory, you withhold it. Makes sense. But it also means that you can have a good faith but mistaken belief that information does not have to be provided under Rule 3.8E. And if you intentionally withhold it, you violated the rule. And I believe that is the only way to read the holding in Klein. And I think the thing, and so that's my first point. My second point is that the interpretation that respondents and the government and the Assistant U.S. Attorneys Association put on this distorts the English of the phrase. Intentionally is an adverb. It modifies the words fail to disclose. And what it means, I believe, in context, is that if you're aware of exculpatory material and you don't disclose, and you intentionally don't disclose it, you've committed the intentionality. Now, somebody gave a hypothetical, and maybe I'm picking on Judge Deal, maybe in Judge Deal again, but of the stack of documents in which the prosecutor doesn't bother to go through, and somewhere in the middle of that stack there's an important piece of Brady material, let's say. Well, that's the reckless conduct, which I think is also discussed in Klein. I mean, you don't get away with saying, "Oh, I didn't have the intent because I willfully blinded myself to the information." But the English is that intentionally modifies the language aware.
Mr. Fox, our time is running short, so I wanted to take you in a slightly different direction, if I may. It was interesting to me that the board here departed from the sanction that had been recommended by the hearing committee, and I'm hoping you can speak to why that was and what cases you think we have where similar discipline was warranted and imposed by this court.
Let me go to your second question first, because that's easy. There aren't any. In the context of what we're dealing with here, which is 3.8E violations. There's only one case. Well, there are two cases. Howes, which I think everybody would agree is a very, very different case because of the things that happened, and Klein. I will say to you that I am asking you to make a determination here about these cases in which you impose a substantial sanction because of the importance of this issue.
And in your view, is a 6-month sanction warranted by 3.8E alone? Because as I read the board's report, I thought they were placing a lot of weight on 8.4C and the dishonesty element as driving the penalty up from what the hearing committee had recommended.
I will agree with you that the board report did that. But I will say also that I believe that the 3.8E violation alone is sufficient. To begin with, there is always an inherent element of dishonesty if a prosecutor knows something, knows that he or she has the obligation to disclose it, knows that the other side doesn't know about it, and doesn't disclose it. So it may not fit all of the elements of conduct involving dishonesty, but there's an inherent dishonesty to that. But what I would say to you is that nowhere in the respondents' briefs, or even in the briefs of the amici supporting the respondents, does anybody weigh the other side of the scale here. This is a seesaw in which there's only one, end that's weighted down. The other end of the scale here is that if you withhold Brady material, somebody can go to jail who is an in fact innocent person, not just a person who's committed without due process. That's pretty bad, but innocent people can go to jail. That is an extraordinarily damaging thing. I have said, and I will say again, that I don't believe that there's any misconduct that's more serious than that a lawyer can commit than a violation of Rule 3.8E, because the consequence of that is, to me, more serious than stealing somebody's money. It can be sending an innocent person to jail. That has to be weighed. And indeed, I believe, I was going to say that I said my third point was that the interpretation that the respondents had was bad policy. And I think that's why the policy would be bad. It doesn't weigh that other consideration that you have and I think what Rule 3.8E does properly, and what this court should do in imposing sanction, is weigh that other consideration. Because on the one hand, if the prosecutor is sanctioned, yes, bad things will happen to them. And it happens to every lawyer who gets sanctioned. And prosecutors are not exempt from that. Yes, bad things happen. That's what deterrence is all about. But you got here conduct that's extraordinarily serious, the consequences of which are hard to compare to any other kind of misconduct, and which is extremely hard to detect. I mean, by definition, we're dealing here with information that is not disclosed. And we know in this case, obviously, what the information was, but how many cases, if you don't disclose it, it never comes out. So when you find it, you need to impose a severe penalty. And the weighing, you have to weigh that. And the other thing, and I guess the last thing I'll say, and I'll close with this unless the court has any additional questions, is that there was implicit in a number of the arguments were made that these determinations about Brady are difficult legal determinations. Somebody had, one of the respondents' counsel had this prosecutor sitting in the conference rooms for days debating whether the law required them to disclose this information. Well, it's not a legal consideration. This court doesn't regularly come up with new kinds of evidence. The X-Files evidence, from now on, X-Files have to be disclosed as Brady. I can't think of a single case other than Giglio, which was decided 50 years ago, which extended Brady to, perhaps extended it to another type of information. None of the case, there's going to be a rebuttal argument, so somebody can point this out to me if I'm wrong, but I can't think of a single case this court's decided where you have said, okay, we haven't ever said before that this type of information is exculpatory and has to be disclosed. From now on, it is. There aren't cases like that. All these cases are fact-driven. They're driven by the facts of the particular case and whether the evidence in that case is exculpatory. You can't, there isn't any such thing as exculpatory per se. It's exculpatory in the context of this case. That's a factual determination. And if it's a close case, the way to protect yourself, and this is the Department of Justice's policy, incidentally, this is what this court said in the Zanders case, for example. If it's a close case, you disclose it. And this this image here of prosecutors debating for days the legality, the intricacies of some, obscure Brady doctrine as to whether they have to disclose something, that's not the real world. The real world is a factual determination. And, and it's the Department of Justice policy. It's what this court said in Zanders. And it's what protects these prosecutors. If in doubt, disclose it. If these lawyers, if these respondents had done what they should have done, which is simply, send the report to the defense counsel, none of us would be sitting here today. So the most serious, if you violate the rule, the most serious consequences can result of violating any rule. And it's easy for the prosecutors to protect themselves. All they have to do is disclose. I have nothing further unless there are any questions from the court.
Well, I don't think, Mr. Fox, that you've talked about what that word intentionally means.
Okay, Judge Ali Khan asked me to jump to the sanction, so I will go back. The English, it intentionally it modifies failure to disclose, and there is no bad faith element. I mean, the Department of Justice brief has the virtue of candor in the sense that they say there ought to be a bad faith element, but there isn't. This court didn't put one in there when you adopted it. And the reason for that, I would submit, is that it would be very bad policy to do so. Because if you go back to those two considerations that I was just weighing, the effect on criminal defendants of having a lax standard under 3.8E, which allows prosecutors to say, oh, I forgot about the fact that he had been demoted, or, well, it wasn't, and this is incidentally what I think Ms. Dobie's, to the extent I understood it, testimony was, well, because it wasn't in the findings portion of the report, I didn't think we had to disclose the fact that he had made a false accusation against, or I don't know what her position was, but somehow it was significant because it wasn't in the findings portion of the report that he had made a false allegation of another inmate. If you're going to tolerate that, if you're going to say, okay, we made a mistake, then what you're saying, the value judgment you're making, the policy decision you're making, is that the risk of innocent people going to jail, and we've given you a slew of examples in our brief, doesn't outweigh the fact that these lawyers, in order to deter others from doing so, are going to be sanctioned.
Mr. Fox, can I just, there's sort of a middle ground, I think, between a bad faith requirement and the way the board reads the report. The way the board reads the rule. That might be something like this. Let's say somebody, these prosecutors should have known this was Brady material, and they didn't turn it over. And they're asked, well, why didn't you turn it over? I said, well, geez, I was in a rush writing the summary. I started with the conclusions. There was no conclusion there that he filed a false disciplinary report. It wasn't on my mind. If me and my co-counsel had ever said, should we disclose this bit of it, I would have said yes. But trials happen fast. A lot was going on. I should have known it was Brady. I should have disclosed it. I knew I didn't, but I just never really made a conscious choice not to. That's not quite bad faith, but it's sort of a middle ground. I get the sense that respondents are kind of pressing that type of argument. Do you have a reaction to it?
Well, I don't know what should have known means, if that's the right interpretation.
No, I'm saying that I definitely, not only should I have known that this was Brady material, I knew it was Brady material. I just never really thought that hard about it. There were 7 different things I wanted to disclose in my summary. If somebody had ever said, hey, you forgot the disciplinary action, I wouldn't have said, no, let's not disclose that. I would have said, duh, we forgot to disclose that. Let's put that in there. So that's what I mean. It's intentional in the sense that, yeah, I disclosed a thing that omitted a thing. I'm granting you that it's knowing Brady material. But when I wrote this thing, it just wasn't at the front of my mind. And nobody really ever said, hey, what about this thing that we're forgetting? And if I really thought about it, I would have turned it over. I think that's kind of the middle ground.
And I guess I would say that's probably the aggravated neglect that I guess I have 2 responses. probably that's aggregated neglect. And the second response is that as a policy matter, I don't believe you should tolerate that. Now, it's your rule. You interpret it, you wrote, it wasn't written by the Jordan Committee. And you all are the people that, it's your rule. But if you're going to say that in the context of cases where innocent people have gone to jail because Brady material has not been disclosed, that a prosecutor is excused because of this negligence, and I would say aggravated negligence, of not realizing that a statement or a finding that a witness had falsely accused someone else when that same witness is being called to the stand to identify culprits in the very same scenario of assault against guards. You're going to say that, well, anybody could make that mistake. Well, obviously you're free to say that. I would suggest to you that that's bad policy. And I would suggest to you that when the rule was written the way it was written, with the knowing and reasonably should know standard, and then, after that, if you're aware of the information, you don't disclose it, you're at your own risk. That's the way I would argue you should strike the balance.
When I think about that answer, it raises a number of concerns in my mind. One of them is that, one of them I'm going to pass over very quickly, which is, as the government has argued in a couple of amicus briefs, there are policy arguments going the other way. But I'm passing that over, and I don't want to get into that. When I think to myself, oh, I see the word intentionally is used there, and it's been specifically added after the original draft obtained from the ABA didn't have such a word. I think to myself, well, I ought to look this up in the dictionary and figure out what that keyword really means. And if I look it up in the dictionary, I don't see anything about policy considerations. It's a word that has a fairly standard meaning. If I say to myself, well, how is it used in the law? My colleagues will tell me, we've written about this. We've written about the model penal code and how they didn't like the word intentionally. They wanted to use a more precise word. They substituted purposely. I think of intentionally as purposely, deliberately, more with knowledge and more with knowledge of what you're doing and you do it, or knowing that you could be doing it and not caring, all those things. And I don't hear you arguing for that a different interpretation of intentionally can really work. You came close with willful blindness and this notion of aggravated neglect. Well, willful blindness is equivalent to, the willful part makes it equivalent to intentionality. I'll accept that. But I don't think that that's what we have here. And the third thing I wanted to say that I thought about when I listened to your response is that I don't read the board's report, at least, as containing this kind of finding. The board report does talk about the importance of this, but they don't make a finding of they purposely left it out. They deliberately left it out. They were willfully blind to, they put aside, they knew there was a problem here and they didn't want to think about it, so they put it aside. Instead, the board says other formulations. This is what I mentioned to Mr. Simeone earlier, that don't say quite the same thing. And they're formulations that I at least find not entirely satisfying when it comes to the question of whether we really have the intentionality here that the rule is talking about. And I've been focusing on that word. I think it's different from bad faith. I think it is possible to say that a lawyer was mistaken. It's It's possible to say that in very strong castigating terms. It's possible to say the lawyer was stupid, or all sorts of things that one could say. And they're bad things. The lawyer shouldn't be like that, but they're not intentionality. And the rule says intentionality. And that, I want to give you a chance to respond to that, because that is one of the 2 or 3 things that is most concerning to me in this case.
Look, I understand the concern, Judge Glickman, but I think that the rule would have been written differently if intentionally was not supposed to modify just the act of disclosing.
May I add, by the way, I think the rule has been poorly written and we ought to revise it.
Okay. Incidentally, one of the reasons it differs from the ABA is this is a negative, and the ABA was an admonishment.
Yes, that's true.
But I think if the rule meant what the respondents contend that it means, the rule would say, in more eloquent language, it's a violation of the rules of professional conduct to intentionally fail to disclose exculpatory material, period. Because then you would say, okay, you didn't disclose the exculpatory material. Was it intentional? Well, no, I didn't recognize it. And you get into all that debate. You wouldn't have added in the language, material that you know or reasonably should know was exculpatory.
Well, but no, there's a difference there. If you simply say it's actually, it would raise other, I shouldn't say it quite so categorically. It would raise other interpretive issues. You have a point. I take your point. There'd be other interpretive issues, but you have a point. If you take the word intentionally at face value, it does raise questions of why they wrote this the way they did. But that would be true whether or not they added the reasonably should have known language.
Well, here's what I think what would have happened, Judge Glickman. I think what we'd be doing is we'd be sitting around endlessly debating whether Mr. Klein's good faith belief that the information that he had was not exculpatory meant that he didn't intentionally fail to disclose it. That's what we'd be doing. And in part because I think this is such an important issue, the new or reasonably new language came in to deal with that aspect, and intentionally isn't meaningless. I mean, any prosecutor can tell you that there have been cases in which they have discovered after the fact that a police officer, didn't tell them something. They didn't know it, and if they'd known about it, they should have disclosed it. They didn't know it. They didn't intentionally fail to disclose it. And they would therefore not have violated Rule 3.
Well, or Judge Deal's examples. I mean, forgetfulness or, sloppiness or what have you.
Well, yes, although here we're getting into the aggravated neglect. But yes, let's I don't know. Let's the agent gives you a stack of documents, and on the way home, you fall down and you scatter a bunch of them. And you don't get them. I'm trying to come up with something, but those kinds of situations, or take.
Well, you've been told to write a motion in limine, and you've been given a very short time period, and the focus has really been largely elsewhere, and you're trying to get it all in there, and you've never done one of these things before, and you write, an abbreviated summary, and it's sloppy. And if you had more time, maybe you would have done better. If you had more guidance, maybe you would have done better. This is what you submit. And you think you're doing it, you think you're doing what you need to disclose. And as Judge Deal says, nobody's around to tap you on the shoulder and say, hey, wait a minute, you forgot about this particular fact. Oh, yeah. Well, I didn't think of it that as I was trying to get this thing done. And it's one of 50 cases that I'm juggling and all the rest. Mistakes happen. People, blunder all the time. Usually it's in a law office in, uptown Washington, and nobody catches it. But sometimes it gets caught. And the question is, what do you do with those kind of mistakes? And yeah, a lot's at stake. Well, the government already knows a lot's at stake because if it ever comes out, they lose the case. So, but a lot's at stake, and attorneys should be held to a standard of competence. That applies to prosecutors as well as everyone else. But I'm looking at the language of the rule. And I'm looking at what the board found and what the board said and what it didn't say. And I mean, you see my problem.
Well, but-
You haven't really, said I'm out of my mind.
Well, no, I take the point, but I really think the reason we should have known is the answer to it. I mean, that's a hard standard. I agree with that. And, I'm not sure I would portray these prosecutors as the naifs that it's been suggested by respondents, but nevertheless, 4 or 5 year prosecutors, ought to know that this kind of evidence was exculpatory, as they admit, and I do
I
think.
think they did. They didn't know.
And they didn't disclose it for some reason, and which they should have disclosed. That's a violation of the rule, and I'm arguing for a tough interpretation of the rule.
Do you also argue that they consciously disregarded their obligation to disclose it?
Did they?
Well, the board found dishonesty, and it didn't find
Oh, okay.
dishonesty as we normally talk about it. They found it, the board said, we're making a finding of dishonesty based on conscious disregard of their failure to of this information and the failure to disclose it.
Well,
And I have to say, I don't see the conscious disregard.
well, let's go back to that motion to eliminate.
Which, by the way, I agree with you, was completely inadequate.
Yeah,
I
but
mean, remember, I was on the Vaughn panel. We were bent out of shape at the handling of this by the United States.
right. No, but I want to go back to unpack a little bit about it. Two major problems with it. One, it didn't disclose the false report, the false accusation against another inmate. Two, it completely denigrated what it did disclose. It said, okay, there's been this finding that he used excessive force and made a false report about it, but we don't really accept it. We don't admit that it's true. And there's really other evidence that suggests that it isn't. Well, there wasn't any other evidence that suggested it isn't. That was not an honest statement. What they did was they took his excuse, which had been rejected by the Department of Corrections people, and said, well, maybe his excuse was accurate. And of course, they didn't disclose what they were doing. So, to me, that's pretty dishonest. So
It's funny because one of their supervisors, a fairly senior assistant United States attorney, I forget the name.
Yeah, we could never find him.
Was apparently of the view that, well, this report really doesn't prove all that much. And just because somebody says, here's my finding, doesn't mean that the finding is correct. So.
Well, wait a minute. Well,
I take your point, though. The evidence was against Childs.
It may be that the finding wasn't correct. The Department of Corrections could have gotten the whole thing wrong, but remember, we're talking about Brady here and what has to be.
Yeah, I agree.
Yeah.
Right. This is, for me, a side issue.
I mean, I'm not sure what else I can say about that. I am arguing for a strict application of the rule because I think it's so important. I don't think the court should tolerate prosecutors saying, I forgot to put in the fact that he was demoted. We wrote this quickly, so we left out the most important stuff, although we deliberately denigrated the stuff that we did put in. I don't think that conduct should be tolerated. And I guess let me just close with this, unless you have any other questions. Because obviously the harshness of the sanction clearly bothers the panel. I understand that. But think about what you do in the context of negligent misappropriation cases. Prosecutors, and there's a little bit of this, I think, in some of the amicus briefs, sort of regard themselves as different, but all lawyers are subject to the rules of professional conduct. And lawyers in private practice, the prosecutors don't have to worry about, have to worry about how they handle client money. And if you negligently misappropriate funds from a client, you don't intend to do it. You put the money back right away. You know, you're suspended for 6 months. Now, compare that conduct and the harm, in many cases, the non-existent harm, I guess there's potential harm to client, with a potential harm to a criminal defendant in a situation where the prosecutor doesn't disclose exculpatory information. I don't think they were comparable, but I think the greater sin is the failure to disclose exculpatory information, particularly, and I keep coming back to this, and I tried to close on it once before, and I'll try to close on it now, when all they had to do is disclose. All they had to do was send that report off, and none of us would be here.
Thank you. I'm going to give a few minutes in rebuttal to Respondents' Counsel, Mr. Simeon.
Thank you, Your Honor. So I just want to start with, Mr. Fox said a few times that he was just focusing on the English of the rule. And I just want to push back and say, I think if you take the word intentionally out of the rule, you basically get the rule that Mr. Fox is trying to enforce. But there's a reason why the Jordan Committee put the intentional in.
It would then cover the accidental non-disclosure. It would then cover the failure to fax 5 pages.
I think that's a null set. I looked and
I think it's a null set. We have one in this case, counsel. The failure to fax over the 5 pages, the hearing committee and the board excused as being negligent and not intentional. That's not a null set.
I think as a matter of enforcement, it is. I've never found a case where an individual in Mr. Fox's position brought a charge against a prosecutor for accidentally failing to disclose. I think that's solving a problem.
The rule has intentionality built in, right?
No, the model rule is simply a prescription. The model rule, of course, the reason they put intentionality in is that it wasn't there. The model rule said a prosecutor shall make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused. So basically, the Jordan Committee got Mr. Fox's rule, putting aside Judge Deal's objection that there may be a case out there where you actually get charged for an accidental failure to disclose, which again, I've looked for and haven't found. But the ABA model rule came to the Jordan Committee and they said, we don't think that reflects the reality of being a prosecutor. We think that there are going to be hard calls where you end up, it's information known to the prosecutor, it's information that but it ends up being exculpatory on the law at the time, which you tried hard to disclose. And I think what the Jordan Committee was saying is we don't want that to be a violation.
So Mr. Fox began his argument with the fact that nowhere in the motion in limine did your clients highlight for the court that this was potential Brady and that the court should review it for any additional Brady it thinks needed to be turned over. So instead it was framed as a motion in limine to preclude a cross-examination on an incident. What's your response to that?
So my response to that, Your Honor, is it's actually not Brady, it's Giglio. It's about impeachment of a government witness. And the way that you raise those issues in Superior Court is you file a motion in limine and you argue about what can be used in impeachment of the government witness.
I mean, it's both. I mean, how is it not Brady when the government witness who is being called as the principal eyewitness to identify these defendants has previously falsely accused somebody of an assault in a similar setting. How is that not Brady?
So Giglio, I'm sorry, I may have given the wrong impression. I see Giglio as a subcategory of Brady that goes to the credibility of a government witness. What can be used in impeaching the government witness is a question that's addressed through motions in limine. And again, we had a finding here from the hearing committee. I think I want to go back to a point that I made earlier, which is, there are findings here that the court needs to take into account. And Your Honor said, at some point they said respondents were told to disclose and litigate, and they didn't. Well, so there's a finding here about what disclose and litigate means. They were told to disclose and litigate, and they did. What the hearing committee found was this disclose and litigate approach, disclosing the source material to the court ex parte and summarizing it to the defense, was an acceptable practice used in various circumstances by lawyers in the USAO at the time. Now, the board says what Your Honor said, but the board says it on the basis of nothing. As far as I know, nobody testified in the record that disclose and litigate means give everything to the court and give everything to the defense. That's not what it meant. For at least 4 witnesses testified that disclose and litigate means exactly what the hearing committee found it meant. And again, if Mr. Fox disagrees, and he disagrees with many of the findings of the hearing committee, but there's a process for that. You can file an objection. You can try to convince the board that there was no substantial evidence for that. It would be tough because four witnesses testified to that effect. So you'd have a very hard time showing there wasn't substantial evidence, and he didn't even try. But the board doesn't get to say, the hearing committee found X, but we find not X, unless the board goes through that exercise. This court's cases are crystal clear that the hearing committee is the finding of fact, and that was a finding of fact.
I mean, the finding of fact is that there is a disclose and litigate procedure that is common practice. It does not say if it's clearly Brady rather than a closed case.
No,
it doesn't say and label your motion in limine as a motion to preclude cross-examination and provide no flag that this is Brady information. They're like none of that's in the findings and none of that is in the testimony.
I understand that, Your Honor. I think it's sort of a recreation of reality to say that the individuals involved here didn't know what respondents were asking for. Judge Morin again testified it was not unusual for the government at that time to submit, not just in this case, but in other cases as well, materials for me to review. So he's saying in this case they did it, and they did it in other cases. That's his testimony about what he understood at the time. So this notion that sort of they weren't really asking for it, even though they said expressly, if there's anything additionally that should be disclosed, the government is requesting that. That's a recreation of reality. That's not what was going on. What was going on is they used the tool that you use to argue about what should come in as Giglio. They filed a motion in limine, and they said to the judge, make sure that anything that we didn't put in the summary gets disclosed. And that was the process in place at the time to achieve full disclosure. And my argument is if you give any meaning to the word intentionally, that shows that they did not intend to withhold the information. I know I've been taking up a lot of the panel's time, and I'm happy to answer any question, but I think I feel I've had my last thing that I just want to say, because I think this is critically important, is on some level, we've talked till we're blue in the face about Rule 3.8E. And on some level, the most important thing in this case is Rule 8.4C. There's a reason, why the public member said, this just doesn't look like dishonesty to me, because tagging somebody with the stigma of dishonesty is a huge deal. And if you ask me as sort of somebody who practices in the ethics area, what's the result of that? I would say the result of that, and I can't sort of prove this standing here before you, but I would say the result of that is that you have no career in the private sector as a lawyer, and your advancement in the public sector is over. If you're tagged with the stigma of dishonesty, there's nothing worse that can happen to you in the disciplinary world. And so I just want to say that I think that we can all be a little bit, sort of lawyerly about these things, but these are human beings, and they're human beings whom the non-lawyer person here thought were being tagged unfairly with the stigma. And I just want to leave your honors with that thought that really this is an enormously terrible thing to happen to a lawyer.
Mr. Simeon, thank you. Mr. Little, do you want to
Yes,
have
very
the last
briefly.
word?
Very briefly, I want to respond to, I think, something that's happened because of the long period of time it took to prosecute this case through the proceedings. Two things. One, to respond to Judge Deal's question about why there wasn't a reference or why they didn't talk about this maybe in a different way. There wasn't a finding of the hearing committee about this. It was because the position the disciplinary council took at that time was that disclose and litigate what in any capacity violated Brady. They didn't break it down into two different parts. And so the question was whether disclosing to the court as opposed to giving it directly to defense counsel was a violation or not. I think if the disciplinary counsel had taken a different approach and a different argument, the record may have been different. You'll note there's no questions from disciplinary counsel of Judge Morin about any of these things. He certainly could have asked Judge Morin, what was your understanding of what you were doing? He didn't do so because the argument that he had made below and that we refuted, I think, on the record and the findings consisted of that was that disclose and litigate was part of the process. Now, specifically as to the issue of what was disclosed and how, I want to direct your attention to 789, transcript page 789. It's the testimony of Chris Ellen Kolb. And she talks about the process, about theories of admissibility. This goes to your question as well, Judge Deal, about impeachment and why you aren't calling it Brady. I agree with my colleague. It's a subset of Brady. It's Giglio. And at the time, the government was focused on the Shearer and Roundtree decisions that made clear that some types of impeaching information, that some types of derogatory information were not subject to impeachment. If they weren't subject to impeachment, then they would not fall into that Giglio subset for Brady. And so the law has changed substantially in both those ways in the last 10 years. But at that time, that's what the record says about why it was done the way it was done. And I think that's critically important to refute the idea that we didn't create the record we should have as to what disclose and litigate meant. Certainly, if there had been an allegation that they had not disclosed and litigated the right way, we would have refuted that. We never had that opportunity. And unless there's other questions from the court, I appreciate your time. I know this is an incredibly important matter, both to my clients, to the bar, and to the court, and I appreciate your attention.
Counsel, thank you all. The case is now submitted, and you may log off.
Thank you.
This honorable court is now adjourned.